कोई जरूरत नहीं है, आपको फाइल मत ही पढ़िए ज़्यादा। रिकॉर्ड मेरे पास सब क्या ही आप फाइल पढ़ें, फाइल नहीं पढ़ना है हम देखो।
Orders item 3.
पहला केस का फाइल नहीं पढ़ना, वो टाइम नहीं मिलता है।
Item 3 delete filing number 124740 of 2024.
पर ऑर्डर हुआ नहीं पता है।
Perhaps I have not seen the defect, but one set of court fee has been filed in this case, madam.
फाइलिंग आपने डिफेक्ट नहीं देखा?
नहीं देखे हैं, और इसमें वन सेट ऑफ द, हमको जैसा लगता है कि 25 पिटिशनर हैं और वन सेट ऑफ कोर्ट फी फाइल किया गया है। कॉमन इशू और कॉमन मैटर लेकर ये मिनिमम वेज हम ड्राइवर है ये सिटी बस रांची में, हम लोग 25 आदमी और हम लोगों का जो मिनिमम वेजेस पे नहीं किया, इसलिए हम लोग लेबर कोर्ट गए। लेबर कोर्ट ने
इतना सारा केस का इस तरह से there's only how many orders are there?
only one order, common order.
Common order.
Common order. Initial 9 is the common order.
There must be different cases.
There are 5 or 6 cases.
No, you just file it separately. ऐसा नहीं है। 5 केस का एक साथ डिस्पोजल लगा तो 5 केस का एक साथ कर लीजिएगा, कहाँ से क्या फैक्ट हम लोग मिलान करेंगे? सबका प्लीडिंग अलग-अलग होगा ना, प्रोसीडिंग चला होगा। You just can't.
Then
you confine it to one of the one set. ऐसे कैसे होगा? So many cases you confine it to one case. बताइए कौन सा केस को confine करें?
फर्स्ट नंबर कर दिया जाए उसको, और रेस्ट के वन का और रिमेनिंग के लिए हम जो है सो हम लोग फाइल करते हैं।
Are you there for the respondent?
Yes, madam. I am appearing for
They are
that.
confining it to minimum wages case number 116.
The petitioners may also have to be deleted then. There are
Yes,
25
certainly.
petitions.
They will do the need. WQA number 2024 of 2024. Objection has been raised by the office regarding filing of the petition in connection with numerous cases which has been disposed of by the reviewing order. Counsel for the petitioner has undertaken to confine this petition in connection with minimum wage case number 1 of 2016 and accordingly this petition is confined to minimum wage case number 1 of 2016. So far as the other cases are concerned, the concerned petitioners may have are at liberty to file separate cases. The counsel for the petitioner is directed to delete the name of the petitioners who are not related to minimum wage case number 1 of 2016. आज कर देंगे?
आज वो हम कर देंगे। 2 दिन समय दे दीजिए इसमें।
Within a period of 1 week.
Only a request, my lord, that whatever he does, my lord, he may give it to me also so that my records are also proper.
ना ना वो
नहीं deletion करेंगे जो
प्रोवाइड कर देंगे, प्रोवाइड कर देंगे।
The number, the fresh cause, the
fresh call.
the fresh cause title be filed before this court, and a copy of the same be also provided.
सिंगल कोर्ट फी
पहले आने दीजिए, उसके बाद देखेंगे सिंगल कोर्ट। बिना आइए कि हम लोग वो भी ऑर्डर नहीं करें। Everybody has a separate cause of action for minimum wages. तो सिंगल कोर्ट की कैसे?
For admission, item 5, contents with 868 of 2024.
आपके पास फाइल में ऑर्डर कंप्लायंस नहीं रिजेक्ट कर दिए रिजेक्ट कर दिया हमारा क्लेम
Order has been complied.
नहीं नोशनल बेनिफिट देने के लिए ऑर्डर हुआ था इस बार इसमें लिखते हैं कि विदित को झारखंड सेवा सनिचालक में किसी पदाधिकारी का भी
They have passed a reason order.
Yes, reason.
So you can challenge that, but so far as contempt is concerned, it will not go.
लिबर्टी में भी
Contempt civil 868 of 2024. Also for the petition is present, nobody appears on behalf of the state.
My lord, I'm here.
Also for the state is also present. Mr. Manish Mishra. Also for the petition submits that a reason order has been passed. And the person will reserve the petitioner to challenge the same in the considering the submissions. The contempt proceedings arising out of order dated 21/2024 passed by this court in that case number 2767 of 2023 is hereby brought. Liberty is reserved with the petitioner to take steps in connection with the reasoned order.
From table list for final disposal of item 1, WPL 2429 of 2010.
Yes, Your Lordship. I also, in this case, Mr. Rajiv Ranjan is leading me. So he'll just come to the court in some time. I had asked him at 2:15 will suit him. He said it will be, no, he said it will be difficult for me to sit. He was not well yesterday, Your Lordship. So just wait till he comes, Your Lordship. I would pray, and at the other side also. I know. My Lord, he said he will not be able
He will
to.
not be able.
Let him come.
Please come. Your case has been called out.
I was only praying if it is.
The petitioner is seeking adjournment.
No, I'm not praying.
Of Mr. Rajiv Ranjan.
Yes, yes.
Perhaps he's not there.
Yes, no, my lord, he's coming. No, he's coming to the court. He said I might come in 10-15 minutes late.
So that's okay. But he will not be able to.
No, he should be able to argue. I'm prepared.
He should be able to.
Yes, Your Lordship. I was there till very late yesterday.
250
My lord, he said I find it difficult to sit at 2:15. If 12 or something would be better, Your Lordship. That is what he said.
When you what fact?
250 250
इनको दिक्कत है
नहीं ठीक है तो कल पर रख दिया तो
कल नहीं.
वो भी सुबह 10:30 बजे का थोड़ा इशू ही रहेगा अभी तबीयत ठीक नहीं है
ठीक है तो 12:30 जैसा
1 बजे
एक मैं अप्लाई कर
Item 2, WPL 7063 of 2012.
Yes, petitioner. Where is the petitioner?
Item 2, Delhi list.
I'm appealing for respondent number 2.
Item 2, Delhi list.
List has not been marked, where which matter is this? But it can be,
Daily list.
I will verify.
Mr. Manohar Chandan was arguing for the petitioner earlier. But your name is there.
As a Micus,
Have you not as a license? Your office is here in this case.
I will
But
verify.
Mr. Manoj Chandan was arguing this case.
Yes, my lord. Mr. Manoj office is doing this matter.
I will verify the issue because it's not appearing in our list. So I do not
On your
know.
list it's not.
I mean, it has not been marked in my office list. Your Worship.
But
I'll
it is
verify.
very much there.
Yes, Your Worship, I'll verify the file. It might have been missed out. Your Worship. My deepest apologies for that.
List का पहला list.
My
Maybe
apologies.
that your office is
Yes.
not interested because Mr. Manoj Chandan has been arguing this case. Siddharth Ranjan appeared on the last date. Rejoinder has been filed.
Yes, my lord.
Readings are complete.
Who has filed the rejoinders? With that, okay?
Respondent number 2, from my side. Lord.
We joined it.
Yes. Rejoinder has been filed on 25/11/2024. Through Manoj Tandon, junior to Manoj Tandon, Mr. Manoj Tandon.
Mr. Manoj Tandon has a wakalatnama in this case, must be added.
Yes, ma'am.
है ना? हाँ, बताइए.
Lordship is in legs in court number 1, Lordship. Let it come on second half, Your Lordship.
What is the matter?
Yes, Lord. Matter is regarding the petitioner has awarded some work to the respondent number 2 regarding the providing of security services in the university, my lord. I have agreement was executed, my lord, as per the terms of the agreement and as per the amount which was paid to me, my lord, being the respondent or to contractor, my lord. I have paid the entire amount
Now
to
it is the principal who has.
my lord. Whatever amount they have paid, they are also admitting this fact. Okay, whatever amount has been paid,
Let it come at.
my lord.
And who is representing the workmen? They are for the management.
Yes,
Who is the workman? The state will be represented.
my lord. Mr. Ravi Prakash is appearing, my lord.
I'll ask him to be here in the second.
Yes.
Item 3, WPL 328 of 2015.
I'll give it to respondent.
Where is the petition?
The last date also they had sought for time duration.
We'll dismiss the case. What is the matter?
It is regarding charging of penal rent against the gratuity. They have preferred against the award that was passed, whereby it was directed to us that if he is occupying the quarters, then we may adjust.
Number 328 of the petition. Nobody appears on behalf of the petitioner. The legal counsel for the state is present.
Respondent BCCL.
Respondent BCCL is present. On 23/10/2024, the matter was adjourned on the prayer of the petitioner, and he had submitted that on the next day he shall not.
11th December.
And he had submitted that on the next day he shall not seek adjournment. The matter was directed to be posted on 20/11/2024 to be taken up at 2:15. The appears that on that day the case could not be taken up. When the case is called out today, neither any adjournment slip has been circulated, nor any prayer for adjournment has been made, and nobody is appearing on behalf of the petitioner. Consequently, this petition is dismissed from the court. Awarded?
Yes, sir.
Committed. Prayer for
Item 5, WPL 1935 of 2021.
yes, petition.
Is to clause annexure 1 and annexure 2 that are the orders passed by the controlling authority and the appellate authority under the payment of gratuity.
What is your ground?
The ground is that the services of the employee was not terminated, therefore you cannot withhold the gratuity amount. This was the order passed by the controlling authority. Against that, we preferred an appeal before the appellate authority, saying that he is guided by the conduct, discipline and appeal rules, whereby we have the power to continue with the proceedings even after the retirement. This has been upheld by the Jaswant Singh. The judgment was ruled down by the Honorable Supreme Court in the case of Ravindranath Chaudhary, holding that the management has power to proceed with the disciplinary proceedings. We preferred an appeal before the appellate authority. The respondent did not prefer any appeal. Now he has
He has
modified.
attained the age of superannuation.
Yes, and he has been dismissed.
He has been discussed.
He has been dismissed.
So, gratuity has been withheld.
We had withheld it, but there is a direction.
Is there any forfeiture?
No. The problem is that he holds. Kindly come to page number 34.
34.
51. Sorry, 50. Issue number 1. Whether the respondent has committed an act or acts which constitutes moral turpitude.
Which one is incidence? It is internal page?
15 of the appellate authorities.
Okay, issue number.
Yes.
What was the allegation against him?
Well, it's reasons. There was a raid in the house of the respondent, and during the raid, incriminating documents have been recovered. There is an allegation that the respondent amassed more than 43 lakhs with disproportionate assets compared to his known source of income. A criminal case has been filed against him, and also there is a disciplinary case pending against the offence. The offence, if proved, would constitute an act of moral turpitude, applying the ratio laid down in Ramlal Bhaskar's case. And finally, at page number 75, internal page number 39. Yes, in the middle, in the light of what have been discussed herein above, I have no hesitation. 39, internal page number 39.
Reasons that respondent has done.
Reasons के थोड़ा सा ऊपर 2 line. In the light of what has been discussed herein above, I have no hesitation to say that the respondent has committed an act which falls under the expression moral turpitude. After that, he passes an order modifying the orders passed by the controlling authority, and now he directs us to make payment of interest also. That was not the direction of the controlling authority. Reasons means reasons.
I have no hesitation to say that he has committed an act of moral turpitude.
Yes.
But in spite of that, there is a direction to pay.
Not only the gratuity, now he modifies the order of the controlling authority and says you make payment of interest also.
Then once he comes to a finding that it's a case of moral turpitude,
Yes.
how the consequent direction has been issued?
That is the error, ma'am.
Who is for the respondent? Nobody is appearing.
Twice they appeared and said that he will file counter.
Aditya Raman, he comes to the court every day.
Aditya Raman is for the Union of India, I think. Deepak Dubey was appearing.
There is only one respondent.
मैंने बताया. Oh, that day he had requested that Deepak Dubey is out of station. Aditya Raman had come.
Where is Mr. Petrol?
And this is covered by your lordship's directions in WPL number 2723.
Remember
That,
that I have decided one.
yes, that he cannot enter into the merits of the disciplinary proceedings. Apart from it, when there is no appeal by the respondent, interest cannot be awarded.
See, the authority holds that he is guilty of moral turpitude.
Yes,
The law says that in order to hold that a person is guilty of moral turpitude,
yes.
then the criminal case he has to be convicted under.
I had argued one matter that it has to be an offence proved by a criminal.
That's right. That's right.
So that is the law as on date.
So what happened in the criminal case?
The criminal case is pending. CBI has filed a charge sheet against him. But he could not have at least awarded the interest amount, and whether to enter into the merits of the disciplinary proceedings that the director was wrong, you should have completed. And before the order passed by the appellate authority, an order of deemed dismissal was passed by the chairman Coal India Limited against him. So this reasoning is
So
also
that dismissal order was also passed.
Yes,
So in spite of order of dismissal, if an order of dismissal is passed as per the provisions of payment of gratuity and there is a question of payment of gratuity,
he has to be convicted for an offence involving murder. That part.
implicit dismissal is not.
Kindly come to page number 30.
So as of now, you are only aggrieved by the grant of interest,
In fact, madam, that should, I have prayed for questioning, but the fact remains.
and then the payment of gratuity, if any, will be subject to whatever.
He has received the gratuity amount. In the direct appellate authority says you submit a bond before the respondent and they would release it. If you are convicted by the CBI, you
So
return back.
that part is already over. Now what is remaining? Remaining is only
Interest
the
part.
interest part. And there is no appeal against police part.
No.
But where is Mr. D? Counsel for the petitioner submits that a criminal case was instituted against the private respondent and the criminal case is still pending. The controlling authority had directed for payment of gratuity. The appellate authority has directed for payment of gratuity, but no interest was paid.
Controlling authority has directed payment.
Payment of interest.
No, without it.
Controlling authority had directed for payment of gratuity, but there was no order to grant interest.
Interest.
The appellate authority, upon an appeal filed by the petitioner, has sustained the order of payment of gratuity, subject to a bond to be furnished by the private respondent, as the criminal case was still pending.
And he has awarded interest.
But without any appeal filed by the private respondent, there is a further direction for
Payment of
payment of interest. As of now, the petitioner is only agreed with regard to the direction to pay interest. There be no corresponding appeal filed by the private respondent.
yes.
The counsel has submitted that the payment of interest is not automatic. It is dependent upon various conditions prescribed under the provisions of section 7 of the payment of gratuity.
And that amount was deposited within 1 month of
That's
his.
agreed on order. He submits that when the private respondent did not have any grievance with regard to payment of interest, non-payment of interest, there was no occasion for the appellate authority to direct payment of interest. आपका कैसे है? अभी ऑर्डर ही करने वाले थे। अच्छा हुआ आप आ गए।
Lord, इसमें in this case, it is respondent wants to engage some counsel also.
आधा ऑर्डर डिस्ट्रिक्ट कर दिया।
I'm sorry.
एंगेज करके सवा हो जाएगा।
Instruction हमको engage नहीं करना, client engage.
डिस्मिस कर देंगे। अलाउ कर देंगे। जैसा करना होगा कर देंगे। आपको क्वायर्स करना करिए नहीं तो कल के लिए कर देंगे।
कल कर तो फिर मंडे का कर देंगे, क्योंकि अभी हम हैं आज शाम में नहीं हैं।
ट्यूसडे को सप्लीमेंट केस।
हाँ, ट्यूसडे 17 को। हाँ,
At this stage of dictation of the order, the counsel for the respondent has appealed and has submitted that he has been instructed to engage a senior counsel. He submits that the matter be posted on next Tuesday and he shall not seek any adjournment of that.
मैं also
Considering the submissions, the matter is directed to be posted for further hearing of the case on next Tuesday to be taken up by the court. लेकिन इनका ग्रीवेंस अब बहुत ही छोटा सा,
हाँ,
only on the payment of interest
हाँ,
and no corresponding appeal was made.
ठीक,
Final disposal में तो 15 में डाल दिया,
ठीक,
to be taken up as the first.
मैं
For orders item 7, WPC 3893 of 2007.
this case, Lordship, some time may be allowed, as because there are some petitions are there, Lordship, IA has been there, which is not with me. The file has been
No IA is pending. Is there a pending IA?
most probably, Lordship.
Let us see which IA is pending.
If your Lordship,
For what purpose?
I need to inspect the office file, Your Lordship.
They want to delete petitioner number 2 who has expired. तो उसमें आपको क्या मिलेगा?
क्या है, इसलिए
There is a petition to delete the name of petitioner number 2. Simple. Delete that.
there is an order. I got the order, Lordship, today morning that 2/11/2022. It is in last order.
Yes.
The learned counsel petitioner Mr. Vishal Tiwari has submitted the IA number so and so has been taken on 5/9/18, whereas the legal heirs of the respondent number 2 have been implemented as respondent 6, 7, 8, 9 and 10, but notice has not been issued upon them. Learned counsel for the respondent state Mr. Ratnesh Kumar SC so and so has submitted that the notice may be issued upon proposed legal heirs of respondent number 2 who have been added as the respondent 6, 7, 8, 9, 10. But let notice be issued upon the respondent 6, 7, 8, 9, 10. In the meantime,
Petitioner number 2 के legal heirs को respondent number 6, 7, 8, 9, 10. Notice चला भी गया है, अब क्या ही बचा? Notices were issued.
there is that
Undelivered respondents. Undelivered speed post of respondents have not been received. वकालत कहाँ पर फाइल किया? 20/2/2024 को।
मेरा ही वकालत नो ऑब्जेक्शन में आया एक और 20/2/2024 इट इज माय वकालत आई हैड फाइल
So, petitioner number 2 will be your full brother.
yes thereafter Lordship no instruction after 2024 I don't get any instruction therefore
क्या ही instruction? Paper publication कर दीजिए. They are faceless. थोड़ा खर्चा करिए. तब समझ में आएगा. ऐसे तो नहीं समझ आएगा. अपना आपके अपने भाई भतीजा लोग प्रेस नहीं कर पा रहे. क्या करना है? This speed post has not returned answer.
इसको
कहाँ गए?
ये सब छुट्टी क्या हुआ
ऐड भी नहीं किया गया उनको पार्टी.
मैं 11 के बाद वो 2021 के बाद इसमें कोई स्टेप नहीं लिया गया है 22 के बाद 2/11/22 के बाद कोई
स्टेप
स्टेप
लेने के लिए तो आपको इतना स्टेप लेना है. इसको करना है.
इसीलिए हम जरा सा इसको देख लेना चाहते थे इंस्पेक्शन डाल के हम देख लेना चाहते थे क्या करना है और अगर नहीं बनाया गया तो मे बी परमिटेड टू मेड पार्टी टू देम after giving inspection I made all these things
respondent number 6, 7, 8, 9 and 10, whose details have been mentioned in paragraph number 4 of IA number 4644 of 2021 through the concerned police station. The petitioner to file requisite by Monday. Close this case on 3rd of January, awaiting service.
Matter made WPC 4123 of 2008.
This case will not just, I am praying for some time. But one IA Millard was on record, but since the case Millard was dismissed for non-prosecution, the IA Millard stand dismissed at that time. Again, I have to file the IA number 995. It was on record.
For what purpose?
It has come in orders.
Because for what purpose?
It is Millard for passing of the order by which the court has said that the case is maintainable. That order I have challenged. But since it was on record, but it was dismissed for non-prosecution, therefore the IA Millard stands dismissed at that time. On last occasion, Millard, I was directed to file the fresh IA. But since Millard, the petitioner, Millard is bent.
Direction to pass fresh IA.
That was the Millard overall, perhaps the oral direction given to me.
ऐसा oral चीज मत बोला कीजिए क्योंकि दूसरे कोर्ट में आता है.
No, I'm sorry. Millard, the petitioner, Millard, in fact, is bedridden now. Millard, he has to, Millard.
So this case has to be decided during his lifetime.
He is not, Millard, he is not in position right now. Perhaps his leg is fractured. IA, एक आध हफ्ता में he will be fit and come to file an IA. The IA is very important. The IA number 995.
What was the IA?
But the IA whereby the court has decided that the case is maintainable. The SR case is maintainable. The SR cases were decided long back in the year 2005. The court has held that there is nothing wrong in possession and of the land. And thereafter another.
Yes, sir. In the SAR case, the final order was passed.
Yes.
That is under challenge.
That was not under challenge. That was
Okay,
never
sir.
challenged. He has filed another case in the year 2009 by one of the.
What is the order included in this case?
Annexure 8, page 39, मतलब only notices have been
case
issued.
number?
Page 39,
No, this is SAR only. Just a minute.
Not the annexure 6 Lord I can see.
Only you have come only against a notice.
No.
What is the nature of the new order? Let us have a look. बताइए क्या है?
तो आइए में है आइए
आइए में तो आएंगे ये बताइए ना क्या है? Issued order क्या है?
आइए को फाइल करता है
कोई बात नहीं, आप issued order नहीं पढ़ेंगे तो हम ही को पढ़ना पड़ेगा, फिर हम order पास करेंगे.
So the IA Millard, the order thereafter Millard was passed, by which the court has said that the case is maintainable. That I have challenged. So that is the important document that we looked into. Therefore, Millard, I am saying that kindly allow me to file a fresh
So let
ID.
us see what is the nature of order passed. Then you were asked to give your evidence. The matter remained pending only before that.
But that I have to inquire.
Inquire the order पढ़िए ना आइए.
नहीं 2008 का मैटर
अरे
है.
नहीं, आइए में जो order आप challenge देते
This IA order is also 2009 order.
Okay,
2009. Therefore, I am
the proceeding did not conclude.
Millard, that I am not sure. I have to
It,
inquire.
as per the IA itself, the proceeding did not conclude. कैसे बोल रहे हैं आप?
कहीं Millard, the IA was
यहाँ
filed.
शोकस फाइल कर दीजिएगा, उसके बाद जो ऑर्डर होते रहेगा यहाँ पे फाइल करते रहिए. SAR ऑर्डर के अगेंस्ट अपील होता है ना? नहीं होता.
The SA
You
order.
have filed a case before this court against the showcase.
Against the so-called and the order by which the court has said that the case is maintainable. Although it is not maintainable. The earlier it has already been decided, the gratuity kata will come. This issue was decided.
Kata का point तो यहाँ पे क्या है?
The court has said that it is maintainable. It is not at all maintainable, it is on my ground. Knowing fully well that the case is...
Whether a case is maintainable or not maintainable, whether the res judicata would apply or not apply, who are the parties before the court, the SAR officer cannot decide these issues.
But he has not decided, therefore I have come to
So
this.
therefore, we'll ask him to decide, if not decided. In interlocutory statement, notice के statement अभी file कर दीजिए और 2008 से इसको pending रखिए.
The pending, it was
ठीक है.
dismissed, Lord. Since earlier another counsel was appearing.
वो counsel से मतलब नहीं है ना, party से मतलब है.
Therefore, Lord, I am saying,
Therefore.
हम 2009 का ऑर्डर है, इसको थोड़ा देख लेते हैं whether it is pending or not.
order है, we just.
Whether it is pending still or not.
We will not bother.
I am asking for only 2 weeks time. IA without IA, my lord, unless and until the case is maintainable.
IA तो dismiss किया already.
God, it was dismissed for non-prosecution. Yes, yes.
It was simply closed.
It was simply closed because the case was dismissed. Lord, kindly see the order by which the case was dismissed for non-prosecution. The IA stands dismissed without going into the merit. Since the case was dismissed, therefore the IA stands dismissed. Last occasion, my lord, I prayed, my lord, for time to file IA. इसको 3 हफ्ता का, it's an old matter, my lord. I have to inquire whether the case is in what stage. I am not aware, my lord, because पुराना.
Sir, restoration order
Restoration, the way the case was dismissed, can we see? The order is one.
you have undertaken at the time of restoration that you will argue the case if the case is restored. Argue. That is a condition of restoration. देखिए order आपको सूट order.
आपको
पढ़ लीजिए और सेकंड हाफ में आ जाइए आप. नहीं तो हम अगर if you do not go by your undertaking at the time of restoration, I will dismiss the case here.
my lord, there is no order. I have said that I will argue.
Sorry.
It was simply. It was
The
simply.
case will be argued if the case is restored.
Lord, I am ready to argue, but the IA petition is
You
to
argue
be.
the IA also.
The IA is already dismissed.
No,
For this.
because it is dismissed by the same order, no? When
Yes.
the case is restored to its original file, you argue the IA also.
On last occasion, I have.
On the very same order by which the case was dismissed for non-prosecution, the IA was closed.
IA was closed.
Now that order does not survive anymore because of restoration, right? Your IA is very much there, you can argue it.
My lord, on that day, my lord, I was told that the court has said that since the entire case was
लेकिन
dismissed.
उस दिन कोर्ट में क्या हुआ? आप
नहीं, हम ठीक है, वो नहीं कहा.
ऐसे
Lord,
नहीं-
my lord, I was arguing down that the argument. The court has said that no, the IA is not alive now. So I will pray for 3 weeks time, not to file. In the interest of justice, I am praying.
2008 का ऑर्डर नोटिस स्टेज में आकर यहाँ पर पेंडिंग करके नहीं चल सकता.
नहीं तो 2008 के बाद dismissed, Lord, because another lawyer was there. my lord. इसमें कोई since when
आपका जो मैटर है उसको हम लोग फाइनल ऑर्डर करने का ऑर्डर कर देंगे. अगर यू आर स्टिल एग्रीड बाय इफ इट इज नॉट क्लोज्ड सो फार.
हाँ वही पता करना.
If not closed, I will observe it. If not already closed, and you will have your right to avail your remedies against the order passed.
I am praying, my lord, at least little adjournment is given so that I will also go through the file. I was not prepared today because I thought, my lord, the IA, my lord, the court will direct me to file another IA.
नहीं कुछ आइए का कोई बात नहीं.
थोड़ा सा.
आपका ये इंटेलेक्चुअली स्टेजेस में केस 2008 से अभी तक यहाँ पे चल रहा है कोर्ट में. These cases are burden number, right? दो ही चीज हो सकता है. Only two things can happen. Either the case has been disposed of by the concerned authority, or the case is pending, right? If the case has not been disposed of, we will pass an order for disposal of the case, right? All the points will be left open for decision. You can argue everything over there. And if the case has already been disposed of, this case has become infructuous for all
the IA Millard which I have filed, the order of 2009 shows that Millard, every point was taken. That the principle of gratuity kata will come. Even the court has not
If the
considered.
case has not yet been decided so far, right? All the points will be kept open. इतना तो है आपका पूरे अधिकार को अच्छी तरह से प्रोटेक्ट करती है हमारे। We will not harm you in any manner whatsoever. But इस तरह से interlocutory stages में 2008 से कितना साल हो गया? How many years?
It was dismissed.
No, how many years? Tell us, how many years? This case is not going to be attended. I will not. आप second half में बहस करें, जो आपको बहस करना।
At least 1 week time.
No. No.
A latest position, let me know the latest position, Millard. What is the case?
It remains. There was a stay order till the appearance of respondent number 5 and 6.
Yes,
Who is
they
the
have
respondent number 5 and
appeared
6?
in a long way.
Where are they? Where are they? जब केस DFT हुआ, उसके बाद तो restoration में तो notice नहीं हुआ होगा। हाँ, they will say हमको तो आप क्या है? ये dismiss हो गया, हम क्यों appear होंगे? See, the वकालतनामा does not survive. Restoration में you never pointed out to the court that there is a private party also, SAR case है। आज के दिन में आपके favor में कैसे ही order?
Notice, again the notice is required to be.
वही ना, यही तो बात है ना। 2008 में फिर से respondent
It was dismissed for pretty long time, therefore it was delayed, Millard. It was not the.
No, very long adjourned matters.
Only for 2 weeks, Millard, I am playing. Let the IA come, Millard. The IA is very important. Then I am not required to file, but some time. So that the latest position I will at least some instruction I will get. 1 week at least. 1 week at the last chance.
This case was dismissed not long back. It was dismissed on 1/9/2021.
21.
2008 का केस 21 में डिसमिस हुआ। लॉन्ग टाइम बैक कहाँ हुआ?
2021 में हुआ।
2021
It is since, Millard, I am not aware of the fact, but since another lawyer was appearing, Millard, kindly see, the fresh Wakaltnama had filed in the year 2020, after, Millard, at the time of restoration. I have come in the year 2022.
Respondent number 5 and 6 have been held.
नहीं आ जाएंगे।
कैसे आ जाएंगे?
My lord will issue notice. They will
I will not issue notice because I am not satisfied with the case at the threshold. I will not issue notice. Why should I issue notice? Restoration के समय तो आप issue notice नहीं करेंगे।
नहीं हम कैसे कराएंगे?
हम तो बस यहाँ नहीं चलेगा।
The court will not.
I am not satisfied with the case. Interlocutory stages में SAR केस में आप इस तरह से करिएगा, कैसे चलेगा?
The order, Millard, whereby the case has been held to be maintainable, Millard, it cannot be said to be an interlocutory order. The principle of restricted kata, Millard.
उसके बाद फिर ये था ना, नोटिस करिए, शोकॉस करिए, उसके बाद फिर बाद में एविडेंस फाइल करिए।
2009
ग्रेच्युटी काटा भी कैसे डिसाइड होगा विदाउट एविडेंस?
2000
You tell us how the principle of gratuity kata can be decided without evidence. Tell us. Even for gratuity kata, evidence is required.
Madam. But the order is already on record. The order which was passed earlier is already on record. But for the interest of justice, Millard, the opposite.
Interest of justice की बात कर रहे हैं 2008 से या pending?
नहीं, because of the dismissal of the case was pending for Petrol.
Dismissal 2021 में। इसीलिए
So
because of
2008 से it was not listed to till 2021.
किसके
I have
कारण?
never taken time, Millard. Can you see, Millard? The earlier council has also not taken time. It was listed for 5-6 years, Millard. हम इसमें the parties were appeared at that time, Millard. They have appeared.
आपने कहा था कैसे? कहाँ का कैसे बताइए?
रांची
रांची का है ना? SAR ऑफिस से बताइए ये केस का क्या स्टेटस है? राइट? आज पर दस और 2:15 बजे आके बताइए।
सवाल
SAR केस नंबर 155 और 2008-9 का क्या स्टेटस है? 2:15 बजे। और अगर स्टे है तो किसके कहने पर स्टे? कोई तो होना चाहिए ना ऑर्डर
Item 9.
That is सवा 2 बजे.
Item 9, WPL 5120/8.
Yes, Your Worship, on the last date, I was directed to take instructions from my client regarding the addresses of the respondents. Your Worship, we have spoken to them. The depot itself has closed down, and since the orders and all the details pertaining to the case are back on 1990s, Your Worship, they have no records whatsoever. And they're not able to find out upon whom or what address it has to be served. Either a paper publication may be made. What is it? Your Worship, minimum wages was being claimed by the respondent workmen through the. But was preferred. So, but
जितना इसमें खर्चा नहीं है उससे ज़्यादा आपको पेपर पब्लिकेशन में खर्चा है. Right? We ask for publication in National Daily. You know how expensive it is. I don't want to fight for minimum wages. Indian Oil Corporation is fighting. Are you serious about this case? Yes. You go and seek instructions because paper publication करना होगा. National Daily 2 पेपर. जितना का अमाउंट नहीं है उससे ज़्यादा खर्चा आपको लग जाएगा. पता करके आइए, पूछ के आइए. You ask your counsel. You ask your senior whether he would still like to pursue this case because बिना पेपर publication के तो नहीं है. और उनको पार्टी भी नहीं बनाया. Paper publication. 3,400 रुपये के लिए आप लोग लड़ते. Or minimum wages. Unheard of. You just seek instructions from them. If you want to still contest this case. सवा 2 बजे. Yes.
Item 10, WPC 5138/2008.
Yes, petitioner. There is a petitioner. The orders need to know. Petitioner closes. Mr. Mishra? Mr. Manish Mishra is there? उनका वकालतनामा है इसमें. Mr. राजीव रंजन का वकालतनामा है इसमें.
Your Worship, may I just pass over for one or two cases. I will seek instruction. I will call
Yes,
Manish
Mr.
Mishra.
Mishra. So many persons have signed wakalatnama. And I don't know what happened on the last day. Nobody appeared. Notice was directed to me. Shoot to the petitioner. They are practicing advocates here. We will not unnecessarily adjourn the matter. You call it? Yes. कोर्ट यहाँ पे नोटिस करते रहेगा पिटिशनर को. 5 आदमी वकालतनामा फाइल करेंगे. Right?
Item 11, WPC 5164/2008.
Only one IE has been filed, madam, in this case for substitution of legal heirs of respondent number 6.
This is land acquisition case number 34 Were you born? Yes, counsel. Were you born in 63?
No, my lord.
क्या चल रहा है यहाँ पर?
My lords, actually, this is not a case of land acquisition. Actually, it's a case of settlement, my lords. That settlement was earlier made, my lords, in the year 1963-64, my lords, under section 53 of SPT Act to the, my lords, private respondent, my lords. And subsequently, my lords, they were in the position, and all of a sudden, settlement officer, my lords, has directed to delete the name of the private respondent and record the name of the, my lords, petitioner, my lords. And subsequently, that order has been challenged before the commissioner, my lords, and commissioner has specifically stated in Annexure 1, my lords, that is the impugn order, my lords, that, my lords, that
Why
order.
the substitution petition? People are losing faith. Generations to generations मर जा रहे हैं लेकिन केस डिसाइड नहीं होता. कौन है बताइए? लीगल केस का नाम बताइए कहाँ है?
Legal is of respondent number 6. His wife, son and daughter.
That is IA number.
IA number 4115.
He died in 2010.
2010.
Filed in IA in 2024.
My leadership in para number 3, we have mentioned that respondent number, intervener respondent number 7 filed the supplementary affidavit on 3/4/2024.
Respondent number 7. Is he relative of this person?
Informed that respondent number 6 died on 24/4/10.
They are relatives apparently. Isn't it? IA number 4115 of 2024 in WPC number 5164 of 2008. This utility application has been filed for substitution of deceased respondent number 6. The name of legal heirs and successors has been mentioned in paragraph 2 of the utility application. Let notice be issued to the proposed legal heirs and successors of respondent number 6 to speed post, for which requisites be filed and handed. Office to track speed post delivery and prepare applicable office note with regard to service of notice. Post this case on 3rd of January 24-25 against service.
Item 12, WPC 5169 of 2008.
Yes, ma'am. In this case also, the leadership on IA has been filed for substitution of legal heirs of petitioner, deceased petitioner, and respondent number 4.
Who has filed this utility application? The petitioner or the respondent?
Petitioner.
Legal heirs of deceased petitioner.
Yes, ma'am.
And respondent number 4.
So for respondent number 4, notice has to be.
Yes, fresh.
Who all are the legal heirs of respondent number 4?
after death of respondent number 4, he is Pradhan of village Kali Patthar, and no new Pradhan has been appointed.
You insert the legal years of him as a person. ऐसा नहीं होगा. प्रधान का successor का बात नहीं है ना, बात ये respondent number 4 का successor. Respondent number 4 may have any, their legal years may have any hereditary right, we do not know. So, you are not aware of this. Why have you filed such a petition?
In this case, I will take instruction from my senior.
Senior से instruction का जरूरत नहीं है. देखिए. This petition has been filed on behalf IA number 3112 of 2024 has been filed seeking substitution of the sole petitioner who is said to have expired on. Where is the death certificate? When did he die?
He died on 19/12/2017.
On who's said to have expired on 19/12/2017, but the utility application has been filed with Wakalatnama of the proposed legal years and successes of the petitioner. But the death certificate has not been placed on record. Further, through this utility application, it has also been stated that the respondent number 4 has also expired, but after the death of respondent number 4, no new Pradhan has been appointed. This court is of the view that on account of death of respondent number 4, his legal years and successors are required to be brought on records. There could be some hereditary right flowing out of the dispute between the parties. The death certificate of the petitioner is also required to be brought on record. Advice counsel for the petitioner raised for time to file a supplementary affidavit in the interview disclosing the legal years and successors of respondent number 4 and also the death certificate of the petitioner. It will be done by third of January, post on 7th of January.
Article 13, WPC 2261 of 2009.
There are two IA applications. Writ application has been filed by JSCB, my lord. My lord, against the company, my lord, we had said the director is Mr. Ratan Agarwal. Subsequently, it transpired that Ratan Agarwal had resigned on that day, my lord, and we have filed a IA, my lord, IA number
Let us see IA 151.
151.
No, 424 is by
Yes,
IA.
424 is there, where we have, there are 7 we have said, my lord.
Para 7.
In fact, let us see from para 6, my lord. Applicant number 2 also resigned from the post of director of the said company, and such resignation was accepted, and accordingly Form 32 has been issued by the registrar of companies confirming that the applicant number 2 is not associated with the said company with effect from 5th of May 2008. Submitted that Sri Rahul Bora, Naresh Kumar and Nishant Kumar are presently the directors of British Cement Company Private Limited. Therefore, we have filed this application for including them as party instead of respondent number 2.
continue to be party.
Yes, sir, it is a company,
It's a company.
but through,
Its director has
through, yes,
changed.
director of something.
Earlier it was through Ratan Lal.
Ratan Agrawal, now it will be through Rahul Vora and others.
The dues are relating to the period.
That is for the period prior to assessment was made, madam, just a moment, madam.
The dues are
May he
prior
resigned after resignation, madam. May he retired, dues are from August.
Inspection is in the month of July.
Yes, madam. He resigned in May. Rahul Agrawal had resigned on May.
जब इलेक्ट्रिसिटी का असेसमेंट होता है तो पिछला कई दिनों कई साल महीने से होता है ना कि उसी दिन से होता है।
May, चूंकि the 126 says, my lord, because the period could not be ascertained, so we have taken 1 year. 12 months.
One year from the cutoff date.
From the cutoff date.
इसका मतलब 18/7/2008 से पहले एक साल।
Yes, madam.
तो फिर 2007 से लायबिलिटी है ना।
He had resigned in the year 2005.
2008.
8. He resigned in the year 2008.
He discontinued from 2000.
May 2008.
So during that time the dues were subsisting.
But as on date, he cannot represent British Cement, madam.
That's right. So respondent number 2. This has been filed by respondent number 2.
But
This
madam,
interlocutory application.
no, that has been filed by me. We have filed.
You have filed. वकालतनामा for respondent number 2 लिखना होगा इसमें। इसके साथ एक वकालतनामा भी फाइल किया। इस आईए के साथ एक वकालतनामा भी फाइल किया। It is therefore great that substitute the name of applicant number 1 as director. इसके साथ एक respondent number 2 बोल के वकालतनामा फाइल किया। और मिस्टर अजीत कुमार, मिस्टर विकास कुमार का वकालतनामा है इसके साथ। आप देखिए भाई।
देख लो।
आप हैं?
I'm the junior counsel, Mr. Ajit Kumar and Mr. Vishnu.
नहीं, आप एक सेकंड जरा देख लीजिए, ऐसे नहीं करें। ठीक है? अब ये क्या है? Amending the cost.
मतलब JCB के जगह झारखंड बिजली वितरण निगम का।
ये तो allow करते हैं।
That may be allowed.
IA number 4533 of 2019 has been filed for amending the cost title of the present application in view of notification number 18 dated 6/1/2014. The council for the petition has submitted that the petitioner would now be represented in the name of नाम क्या होगा?
झारखंड बिजली वितरण 5 I said, madam, झारखंड बिजली वितरण निगम लिमिटेड
झारखंड बिजली वितरण निगम लिमिटेड
through its law officer.
through its law officer. The details have been mentioned in paragraph 5 of it. Considering the interlocutory application, let the petition be substituted in the following manner. Para 5 को quote कर देंगे. Para 5 में जो quotation है the counsel for the petitioner is directed to carry out necessary amendments to the cost. इनकी तरफ से एक fresh वकालतनामा counsel for the petitioner undertakes to file वकालतनामा in the name of झारखंड बिजली वितरण निगम लिमिटेड। ठीक है?
Yes.
ये तो उनका है, आपका नहीं।
Sorry. जो आइए नंबर अर्लियर आइए।
आइए, पुराना आइए उनकी तरफ से। इन्होंने फ्रेश वकालतनामा।
Let it be allowed, madam. We have responded.
You have no objection. You have filed a response to
Yes,
the
ma'am. We have in fact denied it at para 9. We have said that as per our records.
Mr. Ajit Kumar will argue this case.
For short pass over. I for a short. Yeah, Mr. Ajit. Mr. Ajit.
Yes, come.
Yes.
ये आपका तो आइए डिस्पोजल
Yes, ma'am.
ये आइए सुन रहे
Yes.
इसको हम आफ्टर वेकेशन डालते हैं
Obliged.
देख लीजिए इसको, ठीक है. So far as IE number 424 of 2018 is concerned, let this be taken up on 3rd of 10. इसको देख लीजिए भाई आपका
Yes,
क्या ऑब्जेक्शन है, ऐसे लायबिलिटी खत्म होगा नहीं होगा we do not know. थर्ड की वजह corresponding Tuesday, Wednesday को नहीं रखी है. That will be on 7th January.
Yes.
On 7th January.
7.
Who's on 7th January?
Item 14, WPC 4577 of 2009.
In this matter, notices were issued to respondents. So some respondent notice were served, but one has died. Report has come, and I was 6B1, namely Rajesh Bhuiyan. I was directed lastly on 8/4/2024 to file substitution to take appropriate step, but I could not file also. I pray for 2 weeks time. Others also who has been served copy notices, they have not filed वकालतनामा. Although नहीं, इन लोग का जो 6B2 वगैरह को जो हुआ नोटिस 8/4/24 को ऑर्डर में है, उन लोग का वकालतनामा नहीं आया. नहीं आया. आदर्श की तरफ से ये अपियर कर रहे हैं 6B1 का सब्स्टिट्यूशन करना है.
आपको इंस्ट्रक्शन मिला है कि नहीं?
नहीं, हमको अभी तक नहीं मिल रहा है. हम बात कर रहे हैं लेकिन हमको कुछ नहीं.
कितना टाइम चाहिए?
2 वीक्स कर दिया जाएगा.
बाय वे ऑफ क्लास. उसके बाद टाइम दे देंगे.
3 वीक्स कर दिया जाए.
3 वीक्स कर
हम फाइल कर
3 साल हो गया. 3 साल फिर लेकिन उसके बाद टाइम 3 वीक्स आपको चाहिए. WPC number 4577 of 2009. Also for the petitioner waits for time to comply to order dated 8/4. Waits for 3 weeks time. Time till 10th of January is granted to the petitioner to comply with the order by way of last interference. Post on 15th of January. Mr. Pandit, do you have wakalatnama in that case?
My old senior office when I was a full-time associate, I have informed that office.
5 advocates are there on record. We will not issue notice to the petitioner.
Okay.
If you have instructions, it's very good, otherwise we will dismiss this.
My lord, I have informed the office. If your lordship keeps it tomorrow or day after, let me know.
कौन सा वाला से?
Item 10.
Item 10. Mr. Manish Mishra appears. He submits that he shall seek instructions. Post yeah. If you have no instructions, you just let
My
us
lord,
know
I
and
know.
discuss that. We can't.
Oh, obviously.
We cannot trap the petitioner like this.
Okay.
This one. ये वाला. एक और ना? First, yeah, supplementary law cause this it will be there. You just inform us if you have any.
My
Item 15, WPC 4821 of 2009.
In this case, we have
notices has been issued to the proposed respondent. 7-1 and notices has been received by his wife of Prof. Chaudhary, and 8-1 and 2 notices were received by their sisters.
Seven one, 8-1 and 8-2.
Yes.
Notice have been served. 7-1 served to wife, 8-1 served to sister, 8-2 served to sister. Are there other legal years also? 7-1 is how many legal years?
3, 7 and 8, 7, 1
This
is
is ID number?
ID number 2375.
Seven, there were 3 persons. So notice has been served to all of them. Seven one. Seven one
There-
served to wife.
Yes.
What about 7-2 and 7-3?
Mistakenly, it is written as 7-2 and 7-3. They are 8-1 and 8-2. There is one legal error of respondent number 7 and 2 of 8.
Eight one, 8-2. Served to sister. Sister means whose sister?
Their sisters were Mustafa Chaudhary and Javed Chaudhary's sister.
So they, why have they not included the sister as a legal year? Sister will not come in the meaning of legal year. Yes? Daughter will not come.
Yes.
So this is a defective petition. You file your amendment petition. Enough?
Ji.
RA number 2375 of 2020. Will be your office now. The learned counsel for the petitioner seeks permission to file an amendment petition to the interrogatory application. He has also submitted that respondent number आप उसको भी amend कर लेंगे respondent number 7 and 8 कर लेंगे post on 8th of January.
Item 16, WPC 5002 of 2009.
Just trying for short pass. Mr. DC Mr. Tiwari. He has asked to quote number 1 just once.
Item 17, WPC 162 of 2010.
Please note your ladyship, wife of the petitioner has informed that petitioner has died.
Petitioner has died.
Yes, and the counsel for the it is already informed to the court earlier also that the counsel for the petitioner also died.
WPC number 162 of 2010. A report has
prayer of the petition is also for the appointment as a Pradhan.
Item 18, WPC 2786 of 2012.
On the last occasion, Lordship had directed me to file 5 copies of the annexures. The 2 days time I prayed, 2 days time it will be brought to the copy has been served to the petitioner.
Lordship, petitioner has not served us copy of the read petition, Lordship. As per the last order, Lordship.
No.
Not direction.
Open court में तो बोला ही गया था ना, serve करने के लिए.
It was not served, therefore we could not find the counter refusal.
There were no such direction for certain copy, but it, that I can hand him over the copy of the read application. Just for
किस दिन का है प्रोसीजर? 15/10 का है.
जी हाँ, ये है 15/10/2024 पैराग्राफ 6 देखा जाए.
जैसा कोई वर्बल डायरेक्शन
Verbal direction.
नॉर्मली हम लोग नहीं करते.
जी हाँ, verbal direction था that is lacking in the order. Your Lordship had that.
नहीं होगा ना, आपस में आप लोग कॉपी लेने के लिए अगर यहाँ से एडजर्नमेंट होगा और जुडिशियल ऑर्डर होगा तब तो देयर इज नो एंड टू इट.
नहीं,
क्योंकि अगर मान लीजिए
हम
वर्बल
एक
डायरेक्शन
बात-
नहीं था तो हम तो
नहीं,
रिकॉर्डेड
नहीं।
प्रोसीडिंग ही देखेंगे, फिर हम क्या ही करेंगे.
जी, एक बात बता देना चाहते हैं. उस दिन ऑर्डर में हुजूर ने कहा था कि the intervener will be producing the original document deed, but that is lacking in the order. That was not. Your Lordship has uttered. I vividly remember it, but that part is missing in the
Lordship
order.
had asked whether we have the copy of the original deed or not. It was not directed to produce.
No, that was directed.
No, it was not there. It
Directed.
was on came from my lord's mouth whether we have the original deed or not. He said that we have the original copy of the original deed.
अगर ऑर्डर में कुछ एरर है ना तो उसका मॉडिफिकेशन मैं करूँगा. तो हम ऐसे नहीं एज्यूम करेंगे कि
नहीं,
ऑर्डर में कुछ एरर.
नहीं, हम एरर नहीं बोल रहे हैं.
अगर छूट भी गया है तो भी मॉडिफिकेशन फाइल करना पड़ेगा कि उस दिन ओपन कोर्ट में ऑर्डर हुआ था लेकिन इस ऑर्डर में नहीं है. ऐसे तो हम वर्बल
नहीं, पॉसिबल नहीं. ये प्रॉपर भी
पिटीशन फाइल करने के लिए मतलब पिटीशन सर्व करने के लिए कोई जुडिशियल ऑर्डर हम लोग नहीं करते हैं. एडवोकेट आपस में एक्सचेंज कर लेते हैं.
Madam, I'm still ready. I'm handing it over. If my learned friend is not ready to accept.
You are not ready to
Why should I
accept.
not
Just
accept?
now, Madam, I'm handing it over in the court.
Connection है, सब कुछ है, चेक कर लीजिए. सारा रिकॉर्ड का सारा कॉपी है.
Amended
रिकॉर्ड
read.
इतना बड़ा है ये.
Amended copy of the amended read may not have given.
We'll find out the counter.
But the paragraph 6 has to be seen of the order.
They are seeking time. The
To-
respondent is seeking time to comply this.
कितना समय?
2 days time.
2 days.
2 weeks
Well,
time.
with a copy to the petitioner, whatever they will be filing, they will be filing with the copy to the petitioner.
The final order has been passed in the SAR case. It is arising out of mutation proceedings.
No, this is not SCR case.
This is mutation proceedings.
No, the mutation has also been granted. In spite of the mutation, rates were being issued and had been issued for some time, but the state authority has started interfering with the right of the petitioner in constructing of the house. Then, my lord, we came up before this court for restraining them. That is it.
We are claiming the land from the original Rayat Lordship.
So there is a dispute between you and
Yes.
the petitioner.
Serial dispute.
And the state is also claiming right to title interest possession of the property.
No. No.
If there is a dispute between the petitioner and the private respondent, then whosoever is agreed will go to the civil court
Lordship,
for
they are-
seeking injunction or title or whatever.
They are claiming title, their vendor was.
My lord,
they are
I will be
claiming
addressing your
that their
lordship. Let them
vendor
complete.
through Sada Hukumnama came in possession of the land, whereas our stand is through registered documents we are in possession, right from 1935.
So both of you are.
He is from subsequently.
Both of you are claiming possession also.
Yes, Lordship, we are in possession. And they have filed a report, inquiry. One inquiry report has been filed before this court, Lordship, by the state. They have accepted. Up to date, rent receipt has been issued to us.
So there are parallel rent receipts issued in favor of the petitioner and you.
But this writ was filed in the year 2012. But the intervener appeared in the 2024 to object my petition. Just to lordship you may.
Whenever he comes to know, he has filed.
Well, I'm not.
Intervention has been allowed.
Yes, your lordship has.
So now once the intervention is allowed, you file your counter.
We will file. They have received the copy.
How much time do you do?
2 weeks, Lordship.
I will just
intervener
Acha, ठीक है.
submits that he has received the copy of the amended petition during the course of hearing of his case and prays for 2 weeks. Prays for and is granted 2 weeks to file the counter. The counsel for the state prays for 2 days time to comply order dated 15/10 to comply paragraph 6 of order dated 15/10. किसी भी डॉक्यूमेंट का टाइप कॉपी नहीं समझ आए आइए फाइल कर दीजिए कि पढ़ाने ऐसे इलिजिबल करके मत फाइल करिए जो नहीं पढ़ा रहा है तो नहीं पढ़ा रहा है उसके बारे में हम लोग कुछ नहीं कर सकते लेकिन इस ऑर्डर को आप कंप्लाई करिए.
Thereafter, if they produce the documents, I seek time, my lord, to file a rejoinder to their supplementary.
अभी आने तो दीजिए ना अभी तो आ ही जाएगा बड़ी बात.
नहीं फिर टाइम मांगना पड़ेगा इसीलिए बोल रहे थे बार आएगा मैटर इसीलिए ठीक है.
पोस्ट ऑन 3rd of January.
थर्ड नहीं अच्छा 2 हफ्ते को बीत जाएगा छुट्टी में.
For admission item 19, WPL 1839 of 2014.
Requesting for a short pass over. My senior is assisting embassy.
A matter is one of the petitioner was private respondent was he was removed, terminated without following due process, and that order was set aside, and I was directed to be reinstated with full back wages. Again,
Is there any finding of victimization?
yes. Or they have, if there is a finding, my lord, they have given this without following the due process. They have taken the plea firstly, my lord, that he was in managerial capacity. That has been denied by the finding. Thereafter, they have taken plea that previously he has been given notice. Thereafter, I was given promotion also, and that notice is not the reason for my termination. They have taken this plea. The court has denied, the tribunal has denied this aspect also. And thereafter, my lord, if my lord may kindly have a look to page 184, para 19. Yes, sir. The replacement.
How much is the amount of back payments? When were you terminated?
I was terminated 24/12/2004.
He's taking a password. With your data.
Item 16, pass over.
One IA is on the board, IA number 4993 of 2022 for substitution of respondent number 5, 6 and 7. Earlier notices were issued to the private respondent that I have done.
Notices were issued on this item.
Yes, madam. 892.
What happened? Notice has been served. Addressee not found. WPC number 5002 of 2009. Notices were issued to the legally resident successors of the proposed legally successors of reform number 5, 6 and 7.
May I say?
But as per the office note, the addressee was not found. Also for the petitioner.
One private respondent has appeared, madam, and the same family. That's why.
Who has appeared?
From the office of London Senior Counsel.
Who has appeared? Private respondent?
Om Prakash C. He also last occasion.
Madam, my senior counsel.
Yes.
Mr. Rajiv Sharma.
किसकी तरफ से 567 to 567?
Yes.
567.
For the legal years of 567?
Yes, yes.
It is not there in the office.
Madam, they have appeared.
Where is the wakalatnama?
I have not got the instructions about wakalatnama and
appeared means
last date who has appeared.
Appear means what? You have received instructions to appear. I will record it.
For today, my lord. For today
You have received
yes,
instructions. You file wakalatnama. You say that if you want to file wakalatnama for legal years of
I
responsibility.
will for that I will take instructions for my
Go and seek instructions. Whether you will file wakalatnama on behalf of legal years of respondent number 5, 6 and 7. Please go and seek instructions and come back. Otherwise, you will have to take fresh steps for service of purpose.
Yes.
नहीं तो पेपर पब्लिकेशन करवाएंगे कुछ तो करवाना पड़ेगा.
I will take instructions.
Come after 5 minutes. Going if you have received instructions, we'll get on. है? Respondent number 5 सबका dead है. Legal years. कब हुआ 5? पहले का.
Item 20, WPL 2735/2018.
Yeah, which as mentioned earlier, my senior is out of station due to some marriage ceremony in the town. Mrs. Mitchell.
Substitution में क्या problem है?
Yes, person.
Substitution allow है?
नहीं, बस फाइल हुआ अभी.
Who has expired?
Workman has expired once. He survived by wife and daughter.
Where is the details mentioned?
Page number 4 also. Of I.
12876 of 2024. Counsel for the petitioner submits that the concerned workman has expired. The death certificate has been placed on record. The utility application has been filed along with the legal years and successors of the concerned workman. The details have been mentioned at the file of the इसको allow कर देते हैं substitution. Counsel for the respondent has no serious objection with respect to the substitution petition. Accordingly, IA number 12876 of 2024 is allowed. The petitioner is directed to carry out the necessary amendments in the first title in writing during the proceeding. Close this case. The court आया है इसका. The court नहीं आया. The inquiry was said to be parent proper.
Yes, ma'am.
Do you have you challenged that order also? That order is not valid.
No.
What was the allegation to be released?
Misconduct of habitual negligence or neglect of duty or work deceptive or corrupt practice. Because the workman has signed the challan of the tires without physically verifying the number of tires.
What is the illegality in this order?
Yes.
What kind of
We mentioned next week or
at the request of the counsel for the respondent was this case on next Wednesday. To be taken up at
okay.
Item 22, WPC 2512 of 2019.
On the last occasion, your ladyship has heard this matter, and ladyship has petitioner has sought time to seek instruction whether the admitted dues has been paid to the petitioner or not. We have paid your ladyship as per annexure A of the supplementary counter affidavit.
In this case, I have taken the instructions. Amount has been admitted. What they are admitting, they are paid. For rest, I will take legal recourse.
any withdrawals?
Withdraw to take.
WPC number 2512 of 2019. The learned counsel for the parties are present. This requisition has been filed for the following relief. A supplementary counter affidavit has been filed on behalf of respondent number 2 to 4, sought by Assistant Director Training within HQ at Employment Training. Respondent number 1.
Respondent number 4, Deputy Director.
Formed by the Assistant Director Training Headquarters. An officer of the state government, respondent,
Yes.
respondent state government. Making a statement in paragraph 6 that by order during memo dated 19/9/2024, the Jharkhand Society for Skill Development Initiative Scheme within bracket J8SSDIS, that includes, has directed to transfer the total admitted duties amount of rupees 53,21,694 to the petitioner. Then when it comes to further petition submits that the said amount has been received by the petitioner and he still has surviving demands, but admitted amount having been paid, the right we reserve with the petitioner to take appropriate steps in connection with any further claim of the petitioner. Any claim of the petitioner, any further claim of the petitioner. Considering the aforesaid submissions, the grievance of the petitioner appears to have been partly redressed. If the petitioner has any further grievance, it is open to the petitioner to take recourse to law as may be permissible and prevailing. This repetition is a problem.
Item 23, WBC 5057 of 2019.
Please, my lord, my senior instructed me to take order for fresh marks.
Item 16.
Item 6.
WPC number 5002 of 2009. As per office note, the notices sent to the legal years and successors of respondent number 5, 6 and 7 have returned with a note addressee not found. Counsel for the petitioner prays for and is granted time till 10th of January to take fresh steps upon the legal years and successors of respondent number 5, 6 and 7 at their present and current office. Two speakers close this case on 12th of February, awaiting service report, office to crack windows and their appropriate office note with regard to service records.
Item 23, WBC 5057 of 2019.
Let's see. The last time order has not been complied by the respondent till you.
There was a direction to bring the record of the malus mutation case as well as connecting case malus. That has not been received malus. So praying for some more time malus.
Who might contact?
Malus, we have written a letter to malus Deputy Commissioner Giridi as well as malus Additional Collector DCLR and Circle.
Have you received any instructions to see
Not
more
yet,
time?
not yet malus.
WPC number 5057 of 2019. Counsel for the state limits that prays for how much time?
4 weeks time.
4 weeks time to comply to order dated 23rd of October 2024. He has submitted that he has taken up, he has communicated the order of this court to the concerned deputy commissioner. Now the deputy commissioner.
Giridi malus.
Dismiss to the deputy commissioner DDG and also to the additional collector.
Additional Collector DCLR and Circle Officer.
To the additional collector, DCLR and circle officer of DDG. But he has
Circle
not-
Officer of Birni.
Circle officer of Birni, but he has not received any instructions. Considering the submissions, the matter is adjourned and is directed to be posted on 21st of January 2025. Then this order along with the order dated 23rd of October 2024 be communicated to the learned Deputy Commissioner VDD to the concerned unit. The service report will be filed prior to the next day. पुलिस वाले जब लेके जाते हैं ना साइन कराने के लिए तब ठीक लगता है। ऑफिसर इंचार्ज के सामने किसी को साइन करना पड़ेगा तब उनको समझ आएगा कि ऑर्डर तो होता है।
Item 24, WBC 6790/2019.
Will Bishop, the LP is still pending, though it was taken up on 12/11.
Your Lordship, a similar matter has been decided by Your Lordship in another WBC number 7479. So last time they have taken time that against that order they have moved before the Honorable High Court in LP number 388 of 2018. LP has not been.
It has not been decided. The notice has been issued to respondent number 5. He has appeared. The matter was posted on 6th December 2024. Now it has been posted on 4th February 2025. 14th February 2025.
WPC number 6790 of 2019, counsel for the parties are present. It is reported that LP number 388 of 2024 is still pending. Post this case on 12th of March 2025 or after disposal of the aforesaid LP, whichever is earlier.
Okay. Item 25, WBC 1265 of 2020.
Make it's 6 petitioners are before Lordship. They have come up before this one court meeting. And the authorities under the Right to Fair Compensation and Comprehensive Loan Acquisition Act failed to discharge their constitutional obligation, the statutory obligation, but by assessing the valuation of the land lot at the market rate. Lord, this fact has not been denied in the counter affidavits which have come. The fact, none of the facts have been denied. Lord, I have specifically stated, they have specifically stated in the application, Lord, in paragraph number 5
Who
onwards.
has assessed the compensation?
Lord,
Who has assessed the compensation?
Lord, it's the land acquisition authorities,
Where is
the
that?
collector. Lord,
Where
they
is
have said,
where is the assessment order?
Lord, so they have not passed that, they have only simply said, no order has been served upon us, simply said, come and take the money. Lord, but no money has been given to us.
But you have not taken it. Or you did
We have not taken. We have not taken it. Now we have requested the authorities, Lord, by filing the application, which your Lordship will kindly find at page 68 of the writ application, and thereafter, Lord, another application, Lord, for requesting to reassess the valuation of the land at the market rate, or Lord, page 68. भू अर्जनवाद संख्या 57/16/16 भू अर्जन संख्या के अधिगृहित भूमि का सही मूल्यांकन करने के हेतु सक्षम पदाधिकारी को सुपुर्द करने के संबंध में वी रिक्वेस्टेड नाउ योर लॉर्डशिप विल काइंडली शक नहीं सेक्शन पदाधिकारी हु हैज बीन lord bed under section 52 of the act, and they are the, as no lord said by the government. Now I want to show, kindly see, Lord, I want to show only few things before Lordship.
This land
The house property,
this land has been acquired for whom?
for the Lord's NIH, National Highway Authority of India, they have also not disputed any of the facts.
There is a process of assessment of
Exactly,
compensation
exactly.
under NHA.
Exactly.
Right? So, yes, madam,
Yes, Your Lordship.
you will consider it.
Yes, Your Lordship. Can you see the counter affidavit, Your Lordship? The award was tendered, Your Lordship, and petitioner denied to
No.
receive the counter.
Kindly see
Okay,
what.
but if they have any objection, then they will proceed under section
Section
4,
3G5, Your Lordship.
3G5. Right? They have a remedy under 3G5.
Yes, yes, Your Lordship. For the quantum.
For quantum, with
Yes.
regard to quantum of compensation, assessment of compensation.
Yes.
Or what? There is no dispute regarding entitlement.
No.
Lord, kindly see. I will request your Lordship kindly see some provision.
कहाँ है आप काउंटर में काम बोले हैं
वो बोली हैं लेकिन फैक्चुअल एस्पेक्ट डिनाई नहीं हुआ है
कोई बात नहीं आप लेकिन यहाँ से तो नहीं होगा ना
ना हम कहाँ कर रहे हैं हम नहीं हुजूर को कर रहे हैं हम केवल सिंपल एक बात कर रहे हैं कि जो जरा सा काइंडली हम हुजूर से रिक्वेस्ट कर रहे हैं कि सेक्शन 29 और 94 ऑफ द एक्ट देख लिया जाए हाउस प्रॉपर्टी है कमर्शियल एरिया है उसके बारे में जरा सा इस चीज को देख लिया जाए काइंडली हैव ए लुक ऑफ इट सेक्शन 29 ऑफ द एक्ट दिस राइट टू फेयर कंपनसेशन एंड ट्रांसपेरेंसी इन लैंड एक्विजिशन इसका सेक्शन 29 देखा जाए सेक्शन 29 और फिर 94 स्पेसिफिक देखा जाए
Para 21 of the
Yes,
counter
sir.
affidavit of the state. Yes,
सेक्शन 29 पाया गया डिटर्मिनेशन ऑफ वैल्यू ऑफ थिंग्स अटैच टू लैंड और बिल्डिंग द कलेक्टर इन डिटर्मिनिंग द मार्केट वैल्यू ऑफ द बिल्डिंग द कलेक्टर हैज टू असेस इट and other immovable property or assets attached to the land or building which are to be acquired use the services of the competent engineer. I am not attached the photographs of the building attached to the land. Those facts have not been made. Annexure 3 may kindly see. Annexure 3 series. Kindly see. Thereafter, Lords, specialist competent engineer or any other specialist in relevant field, as may be considered, 5.5 बीघा से अधिक जमीन है, एवेल्युएशन 32.5 लाख लग रहा है मार्केट एरिया का. See their arbitrariness. Again, I will request your Lordship to kindly have a look at Section 24. Complete a different procedure has to be adopted where a house is standing. I will request your Lordship to kindly have a look of Section 94 again. Section 29 your Lordship has seen, again kindly see Section 94, acquisition of part of house or building. The provision of this act, entire procedure has to be adapted by the land acquisition authorities. In terms of this Plots Act, right to fair compensation, and no doubt not it is the acquisition for the purpose of the NIH. And they have demolished our building. A vulgar demonstration of the arbitrariness. Unfortunate. The poor persons had to rush to this court for this purpose. Section 94 kindly.
कौन सा पैराग्राफ
आप एसेस नहीं कर रहे हैं उसी धर्मेश्वर पर कर रहे हैं कि हमारा ये
Para 11 of the contract 11 and 21.
11?
21.
कहाँ है आप अपना स्टेट को भूला ही नहीं नो डन ऑफ द फैक्ट्स did not say that the statement made by us is not correct. Landed properties are not situated in the market area. I find that rejoinder to it. Circuit officer is not an appropriate authority for the purpose of valuation of the lord's building. See, your lordship has seen below section 29.
You see, under the provisions of 3T5, you have a remedy before the authority. And that authority has got the jurisdiction to determine the compensation. The dispute regarding compensation has also to be raised before the court.
Now, who has assessed the valuation of the land? It is apparent.
They will get it done. They will get it done as per the provision of law. If there is any dispute.
How? Lord, we have come up before this.
Street court में कैसे हम बोलेंगे कि 100 रुपए होना चाहिए कि 500?
नहीं, हम कहाँ करें? Oh, I cannot ask this court to reevaluate the valuation of the land. The assertion is simple, because the provision of
take the admitted amount, you can take the admitted amount and dispute
the provision
you are
of
not even taking the admitted amount.
कैसे ले लेंगे एडमिटेड? जो एडमिटेड होगा उनके कहने से हम कैसे ले लेंगे?
Under protest
हमारा जो अंडर प्रोटेस्ट दे नहीं रहे हैं, उधर दिया 2 दरखास्त दिया नहीं दिया, वही तो लगाया हुआ है कि हम दिए हुए एक वन ऑफ द पिटिशनर फाइल दी एप्लीकेशन.
देखिए अभी yes बोल रहे हैं.
क्या?
Under protest you can receive the amount and then
अंडर
you can
प्रोटेस्ट
dispute the remaining
सबसे
amount.
बड़ा बात एक बात देख लिया क्या? Your lordship can just assess how much a poor person can run to the lord's authorities. When the authorities are acting arbitrarily,
National Highway Act
section
इसमें से बोलिए section 335.
हाँ ठीक है वहाँ तो कर सकता है, लेकिन अब तो लैंड एक्विजिशन अथॉरिटीज तो एक्सेप्ट कर रहा है ना हुजूर कि हम यही वैल्यूएशन ही का एसेस किए हैं. लेकिन सेक्शन 29 का अगर वैल्यूएशन है लॉर्डशिप का एसेस हो. अच्छा सेक्शन 29 देखे ना तो उसमें क्या कह रहा है? What is being said?
अब आप ऑर्डर सुनिए, हम आपकी बात सुनिए. WPC नंबर 1265 of 20.
उसको कहा जाए कि स्पेसिफिस्ट से जो कहता है सेक्शन 29 और 94 उसके अनुसार एसेस हो और हमको पेमेंट मिले. घर तोड़ दिया हुजूर 2 मंजिला मकान. नहीं हम समझते हैं कि हुजूर जुडिशियस ऑर्डर पास करेंगे, लेकिन हुजूर का असर देख लिया जाए कैसे कितना सुंदर घर है तोड़ दिया.
The learned counsel for the petitioner has referred to the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 and has submitted that section 12 that the assessment has been assessment with regard to the value of the land and property involved in the present case has been done in violation of the provisions of section 29 and 94 of the state act. He has submitted that the land has been acquired for the purposes of national highway, but the compensation is payable in terms of the posted act of 2013. The respondents having not done the valuation properly, the present petition has been filed, and the facts mentioned in this petition have not been disputed. The facts with regard to the property mentioned in this petition have not been disputed by the respondents. The learned counsel appearing on behalf of NHAI has submitted that some amount of compensation has been offered to the petitioners. They can accept the amount under protest, and they can still get the matter regarding quantum of compensation decided in terms of section 3T5 of National Highway Act 1956. She has submitted that the quantum of compensation has to be fixed in terms of the provisions of that. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that there is a dispute with regard to the amount of compensation that the petitioners are entitled. It further appears that the petitioners have been offered certain amount of compensation, but they have not received it, nor they have agitated their grievance in terms of section 3D5 of the Act. Considering the aforesaid facts and circumstances, this petition is disposed of, enabling the petitioner to avail the remedy in terms of section 3D5 of the National Highway Act of 1956. And so far as the amount offered to the petitioners are concerned, petitioners are concerned, they may accept the same under protest, and the payment will be made to them upon in terms of the aforesaid Act. Upon due identity.
इसमें हुजूर एक बात लिखा दिया है कि हम लोग का प्रॉपर्टी जो है मार्केट एरिया में है, इसलिए मार्केट रेट पर इसका अवेलेबल, उसको मेरा एक्सेप्शन है, उसको पिटीशन में वही
लिखी नहीं है कि जो आप बोले हैं वो कोई
नहीं, उसको लिखा दिया जाए, एक्सेप्शन है, डिनाई नहीं हो रहा है ना, एक्सेप्शन है, डिनाई नहीं हो रहा है, तो उसको तो कम से कम लिखा दीजिए, उसको लिखाने में तो कुछ घटेगा नहीं हुजूर का, उसको लिखा दिया जाता है। अच्छा, इसमें अथॉरिटी जो है रेफरेंस टू द अथॉरिटी सेक्शन 64 में है, फेयर कंपनसेशन एक्ट में, वो सब लिखा दिया जाता है ना।
ये रिटेल आउटलेट NHI पर इनका एडवर्टीजमेंट आया था, उसके हमने अप्लाई किया, हमारा उसमें सिलेक्शन हुआ ड्रॉ ऑफ लॉट्स के लिए, ड्रॉ ऑफ लॉट्स में हमने पार्टिसिपेट किया, 50,000 रुपीज़ इन्होंने कहा जमा करना, हमने जमा दिया। उसके बाद ये प्लॉट वेरिफिकेशन के लिए गए, प्लॉट वेरिफिकेशन में उन्होंने कहा कि आपका जो लैंड है वो इंटरसेक्शन पर है NHI में, तो आप NHI से क्लैरिफिकेशन ले लीजिए। हमने NHI को एप्लीकेशन दिया, NHI ने इनको एक चिट्ठी लिखी कि आप सर्टेन पॉइंट्स पर हमको क्लैरिफिकेशन आप भेजिए, लेकिन इन्होंने नहीं भेजा, और अगले बार में एक फिर से ऑर्डर निकाला कि आपका जो लैंड है वो NHI नॉर्म्स को पूरा नहीं करता है, बस यही केस। तो इन्होंने बिना एड्रेस किए NHI का जो लेटर, हाँ किसी और को अलॉट, उसके बाद जैसे ही इन्होंने हमको सूचना मिली कि फिर से ड्रॉ प्लॉट्स करने वाले, हमने ऑब्जेक्शन किया, हमने एक IE भी यहाँ इस कोर्ट में फाइल किया, हमने तुरंत इनको बताया कि हमारा केस चल रहा है, आप इसको ड्रॉ प्लॉट्स को रोक दीजिए, फिर भी इन्होंने ड्रॉ प्लॉट्स किया और दूसरे को दे दिया, जिनको दिया उनका भी कुछ काम नहीं हुआ, उनका भी मैटर फंसा हुआ।
किसी को अलॉट हो गया है,
अलॉट हुआ पर अभी वो एग्जीक्यूट नहीं हुआ। ठीक है, अलॉट हो गया, अलॉट हो गया। जब मेरा कैंडिडेचर इन्होंने प्रॉपर्ली कंसिडर किया ही नहीं, NHI ने जो मांगा था वो पूरा किया ही नहीं, और इनका जो हमारा कैंसिलेशन ऑर्डर है वही क्रिप्टिक है और वो अनरीजन्ड है, वो सस्टेनेबल नहीं है, तो इन्होंने कैसे दूसरे को दे दिया? इसके बावजूद कि ये कोर्ट में केस नहीं बनाया ना, पार्टी हम कैसे बनाते हो? तो वो केस होने के बाद ये सब कुछ हुआ है। ठीक है, हम बना देते हैं, थर्ड पार्टी हम बना देते हैं।
सब्सिक्वेंट लॉट में भी आप पार्टिसिपेट
नहीं, सब्सिक्वेंट लॉट में हमको बुलाया ही नहीं।
Well, we had filed the counter way back 1 year before. We had already disclosed that a third party interest has been created. But they have never filed an IA adding that necessary party or party to this proceeding.
कोर्ट अगर परमिट करे तो हम पार्टी ऐड
Which is that letter which was written by NHI to them?
Yes.
Well, it is not by NHA.
Yes, yes. No,
it is by respondent number 2.
Yes, by NHA. Your lordship may see the page 27 of by rate petition, right in Excel file. It is written by the executive engineer NHI, National Highway Division, Ranchi, to Sri Sumant Gupta, the DGM, the respondent number 1, Hindustan Petroleum Corporation Limited.
How did you deal with this letter?
Matlab, this letter only says what documents have to be given for getting an NOC. Matlab. The occasion for NOC had not arisen since no letter of intent was issued to the petitioner. Matlab, what was asked from the petitioner, Matlab, may kindly have just one annexure before at page 25. Matlab, we had asked him to approach the NHAI. Matlab, may I place, Matlab?
Yes, yes.
Please refer to your application received by us as application number so and so on the subject. Please also refer to the visit of the land evaluation committee to evaluate the site offered by you on so and so date. We wish to inform you that the land evaluation committee has the following observation with respect to your offered land. One intersection with village road adjacent to the offered plot and another road to forest opposite to the offered plot. You are advised to seek clarifications from NHAI on the suitability of your offered land for putting up the retail outlet with regard to the observations of the land evaluation committee as mentioned above, and submit the clarification to us by 16 January 2020. In case if you fail to obtain the clarification as noted above from NHAI and submit the same to our office at the address mentioned below by 16 January 2020, your offered land is liable to be rejected. Now, what the petitioner did is, instead of seeking this clarification, he applied for an NOC. That letter he concealed from this court. We have got that letter from our counter affidavit at annexure C. He directly applied for an NOC. Instead of seeking a clarification whether his offered plot is meeting NHAI guidelines,
Without the NOC, the petrol pump cannot be.
it cannot be.
So who has to give the
NOC? The NOC will have to be given by NHAI. First of all, for getting the NOC, an LOI has to be issued. There was no occasion for getting an NOC.
What kind of clarification are you seeking?
Malaj, may kindly have annexure 6, which is impugned. We had said that your offered plot is not meeting the NHAI norms. And why it was not meeting the NHAI norms, Malaj? May kindly have, we have annexed the
If it
guide.
is not meeting the NHAI norms, then on the same plot, so somebody else had offered some other plot.
Some other plot.
Some other plot. Nothing to do with this.
Nothing to do.
So now you don't intend to establish any petrol pump at this plot.
At this plot.
Because for that area you already have an alternative establishment.
Which is meeting the NHAI.
हम बता नहीं
Malaj, kindly have the NHAI guidelines.
नहीं एनेक्सर 5 एक बार पढ़ा जाए ये तो कह रहे हैं कि हम एनओसी
क्या नहीं, पहले तो आप हमको बताइए क्या राइट आप पे बेस्ट कर।
हाँ, राइट हमारा ये है
To have a mandate.
कि इस तरह के लैंड में जब रहता है तो एनएचआई का नॉर्म्स है कि वैसे इंटरसेक्शन में सर्विस रोड का प्रोविजन है। सब कहीं भी जो भी लैंड दिया जा रहा है एनएच पर, वहाँ तो डेवलपमेंट होना ही होना है, तो वैसे हिसाब से सर्विस रोड का प्रोविजन है। वो सर्विस रोड का प्रोविजन हम अवेल करते जब एनएचआई जो मांगा है वो देने के बाद इनका लेटर पढ़ा तो जाए नेक्स्ट फाइल। नहीं आप नहीं एक मिनट, जो एनेक्सर 5
आपको एक बात बताइए, आप एक पर्टिकुलर प्लॉट में अपना पेट्रोल पंप सेट करते हैं, उस प्लॉट में आपका वो पेट्रोल पंप नहीं आएगा, एक सेकंड, लेकिन उस एरिया में दूसरा एडवर्टाइजमेंट होकर या दूसरा प्रोसीजर फॉलो होकर एक दूसरे आदमी को दूसरे प्लॉट के लिए पेट्रोल पंप देना।
ठीक है, तो ये मेरा बिना क्लोज किए मेरा
राइट, आपका राइट क्या क्रिएट हो गया?
राइट इसलिए क्रिएट है मेरा कि उस रोड पर हमारा नॉर्म फुलफिल करता है। ये एनएचआई बताएगा। एनएचआई ने जो इनको पूछा इन्होंने जवाब क्यों नहीं दिया?
एनएचआई को पार्टी बनाई है?
हाँ,
क्या बोलता है
एनएचआई का तो इन्होंने तो जो काउंटर फाइल किया मैडम,
एनएचआई ने क्या काउंटर फाइल किया है?
इन्होंने जो काउंटर फाइल किया है,
इन्होंने नहीं, एनएचआई ने क्या?
एनएचआई ने तो हमारी बात को रिपीट कर दिया। हाँ, जैसे एनएचआई ने स्टेट उसमें स्टेट
एनएचआई पार्टी कहाँ है?
जो
एनएचआई को खोज रहे हैं हम लोग, क्योंकि सारा कहानी एनएचआई नॉर्म्स की बात चल रही है। एनएचआई तो पार्टी नहीं है इसमें।
Respondent number 2, Executive Engineer, Office of the Executive Engineer, National Highway Division.
नहीं, this is not NHAI. NHAI is executing certain works through, इनके through काम कराते हैं वो, NHAI तो नहीं है।
अगर ये नहीं है तो इन्होंने चिट्ठी एनेक्सर 5 क्यों इशू किया? एनेक्सर 5 तो पढ़ा जाएगा। ये पेट्रोल आउटलेट के लिए
इस तरह का जो पेट्रोल पंप का मतलब एस्टैब्लिशमेंट है और ये सब these are absolutely, you know, जब तक बहुत ही कुछ एक स्पेशल आर्बिट्ररी नहीं हो नहीं इंटीग्रेट किया जा सकता। It is not possible.
अच्छा एनेक्सर 5 एक बार पढ़ लिया जाए, फिर आपको नोट्स को जो करना है। ये इन्होंने प्लीज रेफर टू लेटर, जो ये लेटर इन्होंने दिया है, ये एनेक्सर 4 का जो लेटर है जिसमें इन्होंने कहा है क्लैरिफिकेशन मांगने के लिए।
Annexure 4 का letter is addressed to them?
No, to me, to me. And he has considered this letter.
You must have given it to them.
Yes. इन्होंने ये लिखा है, रेफरेंस नंबर है यहाँ, ये एनेक्सर 4 का रेफरेंस नंबर पढ़ा जाए। Please refer to your letter number such and such, dated 9th October 2019, addressed to the Mr. Nikhil Prasad. This is the petition, while which no objection certificate has been sought for. Establishment of new fuel station. In this regard, please find enclosed herewith Ministry's letter such and such, thereby stipulating the guidelines for processing of such cases and grant of NOC. As per Ministry's guidelines, following documents needs to be submitted for considering the case of provisional NOC. तो जब इन्होंने इस लेटर को कंसिडर कर दिया और ये चिट्ठी लिखी थी, इन्होंने इसको एड्रेस क्यों नहीं किया? हमारे पास इतना ही केस है।
This letter has been misinterpreted.
So जो भी हो, लेकिन
The authority says
यही
that in
चीज
our
क्यों नहीं
letter
लिख
we
के
are
दे दिया
asking
कि
for NOC.
मिसइंटरप्रेटेड है? यही चीज लिख के दे देते, हमको इससे ज्यादा कुछ नहीं करना। अगर नहीं है केस तो मेरा कोई केस नहीं। इसमें उन्होंने कहा है, देखिए ये इसका ये जो क्लाउज 2 है, सर्टिफाइड कॉपी ऑफ द प्लान, क्यों? वहाँ सर्विस रोड का प्रोविजन होता है। अगर वैसा है इंटरसेक्शन तो सर्विस रोड देके हम ले सकते थे, उसका खर्च हम देंगे। ये प्रोविजन भी इन्होंने ही लगाया, हमने नहीं लगाया, अपना ही काउंटर। वो कैंसिल होने लायक प्लॉट नहीं है।
You see, by this letter, certain obligations have been imposed upon the oil company. बहुत तरह के obligations oil company के लिए।
तो इनका जवाब तो दे देते हैं।
Undertaking from the oil company's owner, right?
सब कुछ सही है, इनका जवाब क्यों नहीं दिया इन्होंने? बस हमारा इतना ही करना पड़ेगा, कुछ नहीं। इसको जवाब देते हैं, बात खत्म।
Your candidature may be considered for selection along with group 3 applicants as per guidelines.
फिर तो हम कहीं आएंगे ही नहीं, तो ग्रुप 3 में हमारा कभी आएगा ही नहीं। ग्रुप 1 में हम इसीलिए हम ड्रॉप प्लॉट्स में आ भी जा रहे हैं
Group 3 is what?
कि हमारा जो अभी हमने लैंड प्रोवाइड किया वो सही नहीं है, या जो भी है लिटिगेटिंग मैंने डाल दिया ऑब्जेक्शनेबल।
Group 3 is basically he can, once group 1 and 2 are exhausted, in group 3 when it comes he can offer an alternate land.
वो जब आएगा तब आएगा, अभी है
this plot, but he
इसका
can
आंसर
offer
करना है,
an
हमारा
alternate
केस
plot.
खत्म है, इतना नहीं। आंसर तो करें इसका, क्यों नहीं करते?
तो जब आपने आगे फाइल किया तो स्टे हो गया?
नहीं, आइए फाइल हुआ, आइए फाइल की एक्चुअली जैसे ही पता चला हम उनको वहाँ तुरंत इन्फॉर्म किए। 6 जून को आने वाला था, हमने 5 को ही उनको बता दिया कि हमारा वहाँ केस पेंडिंग है, इसमें आप ना करिए। आइए देख लीजिए। इनको 28/9/2021 को ही नोटिस हो गया है कोर्ट से, देखा जाए मेरा। ये 28/9/2021 को नोटिस हुआ और ये ड्रॉ प्लॉट्स किए 6/6/2023 को। जब इनको नोटिस मिला हुआ था कोर्ट का, ये कोर्ट में आ चुके थे, तो इनको ड्रॉ प्लॉट्स करना ही नहीं था।
These are essential commodities. There was no stay order by this honorable court, so draw of lots was conducted. And may kindly see the IA which my learned friend is referring to has been filed in 2023 after the allotment.
नहीं,
हाँ,
आप नहीं
2023 का
नहीं
देख
नहीं
लीजिए सर,
हम देख
आपका IAS
हम बता रहे
2023
हैं, हम बता रहे हैं
What is
इधर
the date of allotment?
देखा जाए
10/7/23 को आपने आगे What is the date?
मैंने एक मिनट हमारा खाली ये देखा
This draw of lots was conducted on 6th of June 2023. If my lots can have annexure A to my counter affidavit, page 13.
ठीक है मेरा
Page 3rd paragraph. We are pleased to inform you that you have been declared a successful candidate in the draw of lots conducted on 6th June 2023. Page 13 of the
लेटर इन्होंने 22/7 को निकाला, हमारा फाइल हुआ 10/7। और मेरे आईए का पेज 19 देखा जाए। मेरा आईए का पेज 19 देखा जाएगा, पेज 19। ये रिसीव हुआ है इनके द्वारा 5 जून 2023 को और ड्रॉ प्लॉट्स किया इन्होंने 6 जून।
स्टे है हाई कोर्ट से?
नहीं स्टे नहीं है,
तो फिर
नहीं
इसका क्या मतलब?
हमने एक रिप्रेजेंटेशन दिया लॉर्ड से।
आपने क्यों स्टे कराया है? आईए मेंशन भी नहीं किया कुछ।
जैसे ही इनको 5 तारीख को तो पता ही चला कि ये ड्रॉ ऑफ लॉट्स करना, हमको थोड़े सूचना मिली, फ्रेश ड्रॉ ऑफ लॉट्स की सूचना हमें नहीं मिली।
तो पब्लिकेशन के थ्रू होता होगा, ऐसे थोड़ी होता है ड्रॉ ऑफ लॉट्स, पेपर पब्लिकेशन के थ्रू होता है, ऐसे तो प्राइवेटली थोड़ी कर सकते हैं। आपने 50,000 रुपये जमा किया, उनको वापस कर दीजिए, फोर्फिट नहीं कर सकते, नहीं तो आपका फोर्फिट कर दीजिए।
वो तो अब ठीक है, आप
इसलिए सही में फोर्फिट कर लेंगे, वो नहीं देंगे आपको।
नहीं इसको
We are quite aware of how they function. चाहिए पैसे?
हमको 50,000 से पहले एनेक्सर 5 का जवाब चाहिए, अगर लॉर्डशिप कर सकें तो।
हर चीज़ का जवाब तुमको एग्जिस्ट नहीं है। कुछ तो डिस्क्रिप्शन इन लोग के पास रहता ही है ना, अनलेस एक्सप्रेसाई कुछ आर्बिट्रेरी नहीं हो इस तरह से।
डिस्क्रिप्शन से एकदम सीधा इन्होंने कह दिया नॉर्म फॉलो नहीं करता। क्यों नहीं करता है? इंटरसेक्शन के चलते नहीं करता, उसका अल्टरनेट।
आप एक चीज़ देखिए, उस लेटर में कुछ ऑब्लिगेशंस इनके ऊपर भी लगाए गए हैं, आप देखिए लेटर।
तो इनका जवाब
देखो नहीं चाहते हैं ना करना, आप समझिए।
इसीलिए तो हम कोर्ट ट्रायल कर
You see, if the NHI asks them to perform something, they will not do it. They are not interested. बोलेंगे ठीक है, हमको नहीं चाहिए, हम दूसरा जगह देखें।
नहीं, आखिरी अथॉरिटी NHI ही है।
नहीं, अगर वही NHI इनको फोर्स तो नहीं कर सकता ना,
क्योंकि पेट्रोल पंप NH पर ही लगना है।
ये समझना चाहते नहीं है, because by that letter certain obligations has been cast upon them also. Undertaking from oil company and necessary alteration include complete removal of shifting of approach road, क्या undertaking है इनका, they are not interested, क्योंकि इनके as per the norms ये जो NHAI ने चिट्ठी लिखी है उसमें ऑब्लिगेशन सिर्फ आपके ऊपर नहीं है, इनके ऊपर भी ऑब्लिगेशन, they are not interested। आप इसका अंडरलाइंग रीजन आप समझिए, कोई दुश्मनी नहीं है आपके साथ। आप जाइए किसी कोई चीज को भाड़ा लेने, उसके बाद लैंडलॉर्ड बोले नहीं इसका पोचाड़ा आपको कराना है, इसका ये चीज आपको कराना है, ऐसा करना है, तो आप हो सकता है यू विल बैक अप। By this letter, certain obligations have been cast upon the oil company also. इसीलिए ये सारे नॉर्म्स तो वो नहीं ना होगा, सेटिस्फाई कैसे होगा बताइए? तो इम्पोज कर सकते हैं एनएचआई इनके ऊपर. This is the reason.
Para 6.7 of our counter, we have given this reason that we cannot apply for provisional NOC today because LOI has not been issued to you. And para 6.7 is.
For the learned counsel appearing on behalf of the parties, this petition has been filed for the following. The learned counsel for the petitioner has submitted that the petitioner had participated in the selection process in connection with the establishment of petrol pump, and a letter dated 9th of October 2010 was issued to the petitioner indicating that one intersection with village road adjacent to offered plot and another road to forest opposite to offered plot has been observed by the Land Evaluation Committee, and the petitioner was advised to seek clarification from National Highway Authority of India regarding NHAI on the suitability of the offered land for putting up the retail outlet with regard to observation of Land Evaluation Committee, and it was also mentioned that the clarification should come to them by 16th of January 2020. The learned counsel submits that the matter was taken up by the petitioner with the Office of the Executive Engineer, National Highway Division, Ranchi, who issued a letter dated 14/1/2020 addressed to the DGM Hindustan Petroleum Corporation, mentioning therein that certain norms which were to be followed as per ministry's guideline, and certain documents were to be issued before processing the case of grant of NOC. The learned counsel submits that instead of taking up the matter forward, the respondents have issued the impugned letter dated 5th of July 2021 stating that the offered plot does not meet NHAI norms. The learned counsel submits that the NHAI never said that the offered plot does not meet the required norms, but such a reason has been assigned, and therefore the act of the respondents is ex speciae act. The learned counsel has also submitted that during the pendency of this case, the respondents had undertaken the selection process in connection with the area, and on 10/7/2023, an interlocutory application was filed in IA number 5921 of 2023 seeking interim relief, and during the pendency, the retail outlet has been established in another plot.
Established.
Okay, has been a third person has been allotted for has been chosen for establishment of retail outlet.
During the pendency एक draw of lots हुआ जिसमें कि उसका selection हुआ, उसके पहले ही हमने objection दे दिया.
During the pendency, there was a draw of lots and a third person has been selected.
Before that,
and before the letter could be issued to the third person, the interlocutory application was filed.
before draw of lots हमने objection file किया,
They
raise
have
किया.
also submitted that before the draw of lot, an objection was also filed by the petitioner before the respondent authorities, mentioning that the case was pending. The learned counsel appearing on behalf of the respondents has opposed the prayer by submitting that the
There are 6.2 onwards.
any particular paragraph
मतलब 6.2, which is third party not being not added. Non-joinder of necessary party.
He has submitted that third party has been selected by the respondents for establishment of retail outlet on 6/6/2023.
Then para 6.
And para
6.4 balance, where we have specified which guideline and for what reason has not been complied.
and he has referred to paragraph 6.4 to submit that as per clause 4.5.1 of the norms for location, layout and access to fuel station along the national highway provided in the NHAI guideline dated 24 of July 2013 for rural stretch, the minimum distance from intersection with the rural road is 300 meters. He submits that it was this norm which was not being satisfied by the petitioner, and therefore ultimately it was intimated to the petitioner that petitioner is not satisfying the norms under NHAI. Any rejoinder file to this?
No, there is a reason. At para 6.7 we have clarified why we did not apply for NOC, which my learned friend is.
And he has also referred to paragraph number 6.6 of the contract.
6.7.
6.7
7.
of the contract affidavit
There is a rejoinder.
to state that the letter dated 19/11/2019 was erroneously issued in view of the fact that the respondents never asked the petitioner to seek NOC from NHAI. Rather, pursuant to their approach to seek NHAI, the National Highway Division Gratuity had issued the letter dated 14/1/2020 asking the respondents to provide a list of required documents for considering the provisional NOC to the petitioner for opening the retail outlet.
Stage of NOC.
He has also submitted that the stage of seeking NOC had not arisen as the letter of intent was never issued to the petitioner.
Rejoinder is filed.
In response, the counsel for the petitioner has submitted that a rejoinder has been filed
Para 17.
to the counter affidavit, and he has referred to paragraph number
17.
17 of the rejoinder to submit that the respondent number 1 has rejected the candidature of the petitioner arbitrarily by cryptic include order, and the petitioner had also deposited the requisite fees amounting to rupees 50,000. What do you have to say to the 300 meters?
300 उसका है हमने दिया है para इसका 9th पढ़ा जाए. As per the NHAI guidelines, provision exists for adjustment modification of intersection. As per the said guidelines, and the petitioner is willing to avail the same.
Council has also submitted that in response to the norms regarding 300 meters as mentioned in the contract affidavit, it has been specifically stated in the rejoinder that as per NHAI guidelines, provisions exist for adjustment/modification of intersection as per the guideline, and the petitioner was willing to avail the same by incurring the consequent expenses thereof, but no clarification regarding the same provision has been sought from NHAI. That's all. Pause for further dictation. Arguments concluded. कल कुछ सुनेंगे नहीं, या तो हम उठा के लेके आएंगे या थोड़ा सा ऑपरेटिव पूछिए, क्योंकि ये सारा सीक्वेंस हमको ढंग से डालना पड़ेगा ऑर्डर में. Tomorrow no further arguments tomorrow. I have recorded every argument of yours.
बाकी जो है आर्बिट्रेरीनेस तो है।
मतलब हम लिखते थे एक्सप्रेसाइड आर्बिट्री आफ्टर सब्मिशन।
Password case from daily list. Item 1, WPL 2429 of the content.
Two prayers from the writ application. One is not for against not the order deciding the preliminary issue, and the final note award which has been passed subsequently. I forward the second prayer of the preliminary issue. But now since the award has been passed, so we have to confine ourselves notes to that. This matter is with regard to discharge. There was a altercation between two workers. Fight took place. He was hit in the nose, bleeding. He fell down, then he hit by a rod in his ears, injury. Doctor examined. It is all within the factory premises happening. They are both of them are crane operators. Then the written complaint was filed in the handwriting of another person, one SPC, signed by the injured worker. Given to that, inquiry done. Doctor notes discharge. He was unfit for 7-8 days. This is the case.
Respondent was there in the first time?
Yes.
No, my lord. When it was mentioned, somebody else was there, but the advocate on record, I informed him. I met him afterwards.
Please continue.
So notes, these are the altercations, these are the cause of incident. Doctor examined and then he was unfit for 7-8 days. Then a proceeding was initiated, departmental proceeding, evidences were laid, and the inquiry officer on the basis of preponderance of probabilities found that he is guilty. Discharge was notes, order was passed. Then not it went to the labour court, but the reference was made. Labour court decided that the evidence is not enough, or some of the persons have retracted from their evidence given in the preliminary inquiry and all those things.
The domestic inquiry was held to be fair.
Was not held to be fair and proper.
Did you lead evidence?
Thereafter not be laid evidence. So therefore now I will not be relying upon the inquiry, not in the domestic inquiry. Now we have to confine ourselves to the evidence which has been laid after the notes preliminary issue was decided against the management. So this being the position, what facts would notes may kindly not directly come to the issues which were framed not for consideration by the court. Page notes. Page 6, not at page 77 of the award notes. Yes, correct. Paragraph 6 of the award. First is whether the termination of the services of so and so is proper and justified. Secondly, whether the disciplinary authority who had issued the charge sheet and the punishment order and accounting authority had issued dismissal letter was conferred with the power and authority to do the same. That the punishment is proportionate. It is a fit case to exercise power under section 11. Now, note second notes issue was decided in favor of the management that the authority had the power. So I will not be referring to that notes. Now the issue note therefore notice boils down to the issue whether it is the preponderance of probability notes is considered. Issue number 1. Findings note start for issue number 1 at page 83. Before that, if Marots would like to see the evidences which were laid before the labour court, three witnesses oral notes was examination was done, oral witnesses. Page 43. These are the sole basis note which has been discussed in the award. Page 43 and 5 note is the oral evidence of Jagannath Das. He is an injured workman. He says no that मेरा पूरा नाम so and so है जगन्नाथ दास है. I was on duty on 14/8/1995. Date of occurrence is 14/8/1995. Paragraph 3.
This is that evidence is that page number?
Page number note 43.
Let us see what the court has done and then we come.
All right. Court note has quoted note all those things. It has gone on the issue that the rod which was used not to hit has not been exhibited, which knows the blood was not. As if not, instead of not examining the preponderance of probability, the workman injured witness has not correctly stated that what has happened to him. I cannot read not entire notes.
Let's see the findings.
Findings. Page 83, bro. Issue number 1. Whether it is justified or not, was the first issue framed. Issue number 1 is related to the termination of service of Sri R.N. Singh, crane operator of TISCO, as made by the management, is a proper and justified. In order to prove the aforesaid issue, the management have examined altogether 3 witnesses. MW1 Jagannath Das has deposed in his evidence that he was working as a crane operator at the relevant time when the alleged incident dated so and so taken place. And on 14/8/95, he was working in an A shift from 6 a.m. to 2 p.m. And R.N. Singh was also, R.N. Singh node is the worker node, is a concerned node. Was also working in the same shift, and one another employee, Sri S.P. Singh, was also in the air shift duty as a monitor operator. Mr. J. Das, who is the informant of the alleged incident dated 14/8/95, and he was further deposed on 14/8 as he was on the reliever duty. He used to relieve 3 crane operators for 2 hours during the shift respectively, and Mr. R.N. Singh, charge-sheeted workman, was given relieving hours of 2 hours from 12 noon to 2 p.m. on 14/8/95, but the said R.N. Singh requested to this witness for giving him relieving hours from 10 a.m. to 12 p.m. noon in place of 12 noon to 2 p.m. But this witness MW1 refused to do the same, and it caused annoyance to the charge-sheeted workman R.N. Singh, and he started abusing MW1 and also inflicted fist over the nose of MW1, and witness J. Das fell on the ground and bleeding was going on from the nose. And thereafter, charge-sheeted workman had again inflicted another blow of iron rod over the ear of this witness, but this witness could not say as to which of the ear this iron blow was inflicted. And thereafter, this witness has deposed that charge-sheeted workman fled away from the place of offence. Thereafter, written complaint was lodged by the witness MW1, and he was also sent for first aid treatment, and Mr. Ganesh Ram was also present there, and Mr. S.P. Singh had written the first blood there. S.P. Singh, who was the supervisor workman, had written down the written complaint on behalf of J. Das. Was signed by this witness on 14, and it is proved and marked as Exhibit M. This witness has further deposed that he was sent to Tata Main Hospital for treatment, where a doctor on duty had given medical treatment and declared him unfit for the job. Witness MW1 has further deposed that alleged incident took place inside the factory premises, and this witness has further deposed that there were stitches given in the right ear during treatment, and in cross-examination this witness has deposed that senior officers Mr. S.P. Singh and Ganesh Ram was present at the time of incident, including others, and alleged incident took place at about 6:15 a.m. and he came before Mr. S.P. Singh at about 6:30 a.m. So Ganesh Ram was also available, and there and MW1 had given his statement before Mr. S.P. Singh and further deposed that after treatment, first aid, he was discharged from the TMH, and at about 1:45 p.m. thereafter he was declared unfit and was on sick leave for 9 days, and thereafter joined his duty, and this witness was further deposed that matter was neither reported to the police nor police made any interrogation on the incident matter, and thereafter this witness had narrated nothing about the incident to anyone else, and thereafter he was deposed only about the incident before the court, and further in para 16 of the cross-examination this witness was deposed as to which of the ear stitches were given during treatment, and further denied about the incident to be false. MW2 Ganesh Ram has deposed that on 14/8 he was also working in a shift as a crane operator in electrical operation department, and Mr. R.N. Singh, charge-seated workmen. Both these workmen were the MW2 and 3 had not retired by that time when they were deposing. Charge-seated workmen and Mr. Dar. Mr. S.P. Singh was also available on the same day. Mr. R.N. Singh, charge-seated workman, and Mr. Jetas were also in A shift duty. And this witness has deposed that he had not seen the alleged incident by his own eyes, but he heard about the incident and also came to know that Mr. Jetas had sustained injury. But how and what? He is saying now. Although not we say that he was present, but as a witness he says that I am yours. But and he has further deposed that Mr. J. Das had narrated that there was some scuffle between him and Mr. R.N. Singh on the point of relieving of duty hours, and some abusing language was also used, and he fell down on the ground and sustained injury, and thereafter his treatment was made in the hospital. And this witness has also he narrates other aspects more, that injury did happen and he was not told by Jaidas and this thing happened. Statement recorded by ST SN Jha in preliminary inquiry and on cross-examination, especially in paragraph 11 of this witness denied as to what has been written in exhibit M1 and never supported about his previous statement dated 14/8/1995. On 14/8/1995, when the preliminary inquiry was held, he gave a different statement. And from perusal of exhibit MW1, it appears that witness MW2, Ganesh Ram, has deposed about the incident of 14/8/95, which was recorded by Sri SN Jha, and Mr. J. Das was sent for first aid and there was bleeding coming out from his ear, but it has not been disclosed as from which of the ear blood was using. And this witness MW2 took Sri J. Das on his moped number so and so and sent him for first aid, and on the way, J. Das told him that he was assaulted by Sri R.N. Singh with iron rod, but this witness has not supported about it in his statement before the court. And except an above witness, MW2 is not an eyewitness and he has not seen the alleged incident, and thereafter MW1's doctors, Mr. Counsel has deposed first aid station is situated in the factory premises for the employee. If they sustain injury, first aid are given to them in the first aid station. In a minor injury case, in the case of severe injury, patients are referred to Dr. for better treatment. And this witness has also proved the prescription slip in the name of Mr. J. Das and prepared by Dr. A. Charan. It is marked exhibit M4 and from perusal of said injury exhibit M4, it appears that bleeding was going on from the ear and there was contusion on right ear and patient was referred to PMH. And in cross-examination, witness M3 has further deposed that he is working as a doctor since 1978 as a senior medical officer, and this witness has further supported that he has worked with Dr. A. Charan. He identifies the signature of Dr. Nod, who gave the prescription. Then at workman R.N. Singh has deposed, he is a charge sheet employee, he has written a statement of exhibit W1, written a statement. He has denied not all that. Not
He has denied
everything.
You have two witnesses for workman.
Yes. And another workman, not SP Singh, who was the supervisor who wrote down the complaint in writing on 14/8, he retracted now. He retracts.
And deposed on behalf of the workman.
Notes, no, he was produced as
WW.
yes, apparently, yes. Yes.
He deposed
on behalf of the workman.
By saying
So,
that, and then he supported the workman.
yes. Now the findings notes.
Did he, was he confronted with the document that he had prepared?
Yes, sir, but he says that note,
Those
these
are
are the
all
dates.
exhibits.
These are all exhibits.
What is the finding?
Finding note is page note 88.
Yes.
After noticing that note, they were turned hostile and then note 11 note primary issue. Page 88 note 5 lines note from the top. I find and hold. I find and hold that management and Substitution have not been able to prove about the incident that is 14/8/95, as well as using of abusive language and inflicting iron rod over the person of Jaidas, and witness SP Singh and witness Ganesh Ram have not supported and corroborated about the incident dated 14/8/95 according to factory premises of this. And it is to be noted that there should have been several workmen available at the place of occurrence, but none of them have produced and examined. And except the above incriminating material, that is iron rod, used in the incidents has not been seized or produced before this court as material exhibit, and as such, on the basis of the evidence as discussed above, I find and hold that termination of service on the basis of charges as alleged is neither proper or justified, and as such, I issue one stands accordingly in favor of this workman. Then about the disproportionality note, again he notes finds
Once he says that it is not
true. But
not
disproportionality also he discusses that even if it is correct, then I find that what language was used and how he did and how the scuffle happened was not properly explained.
The question of proportionality comes only when he is proved.
Proved.
The charge is proved.
Correct.
Otherwise, there is no question.
There is no
of
question.
proportionality.
But he has gone into that also while deciding exit notes issue number 3. Kindly see page 90 note, he says, page 90, fifth line note from the top. I am of the opinion that management have not been able to prove as to what words were spoken or spelled out from the mouth of charge-sheeted workmen. So he says that even if it is an abuse, and he relies upon a 1978 judgment notes, 2009 judgments. and that note the management has failed to produce the iron note if any used against the workman RNC, and such in absence of the cogent material evidence towards the end of the paragraph, he records the same finding, that it is harsh and disproportionate. Nowhere it discusses whether it amounts to a preponderance of probabilities or not. What is not required, like a criminal trial, that notes every evidence has to be examined in that respect. What is to be seen not is the demeanor and not the preponderance of probabilities. If it was there, then that, for a departmental proceeding, that is enough.
Where
And
is the
notes,
evidence of the victim?
evidence of the victim note is also there.
Page
And-
43.
yes, notes.
Yes, lecture
No. It is at page notes. Page. It is a denial note of all the incidents. He was cross-examined. Page notes
I
49.
want to see two things.
Page 49.
One is his cross-examination and further his response. The
Yes.
first response to the captain.
First
That's
response.
exhibited-
The written statement note is total denial.
No, written statement is totally denied,
Yes.
but the document by which he responded to the charge, denying the allegation.
That is not on record.
It is there, we have everything.
Oh, I see. The record is there.
इसीलिए बिना record मंगाए को decide.
Exhibit M by 1 note kindly see the complaint which was written by SP Singh and signed by the concerned
That is
worker.
exhibit M by 1.
That is M by 1.
What is the exhibit response?
Page 78 is a list of documents not which were exhibited. Explanations dated 16/8/95 submitted by the charge sheeted Mr. RNC M3. And the statement of Mr. SP Singh also would be relevant for which is M5 on 14/8/95. M1, M3 and M5 would be relevant.
Just see his cross-examination.
Yes. So it is at note space in lecture 5.
Charge sheeted employee का ना
49.
जो जवाब है इसने पूछा. आप बताइए आपको पता होना चाहिए. पेज नंबर 43. Yes.
Page 49 note is the typed affidavit given by him and notes. Cross-examination note is at page 51. It is a denial note, paragraph 8 note. He said it is Jhuta Mangaran Tarot.
No, I'm talking about the cross-examination of the student.
Yes. Victim.
Yes.
Yes, victims.
Victim is the most
Yes,
important.
but he is MW1 notes.
MW.
MW1.
Page 43.
Page 43. MW1 notes.
Yes, supported that is pretty.
Yes, that's about. I can read note the statements note the MW1. Page 45. मेरे स्वयं से रिलीफ दे दें तो उनको किया, उसके बाद आरएन सिंह कामगार ने गाली गलौज किया तथा मेरे नाक में घुसा मार दिया, मैं गिर गया, मेरे नाक से खून बहने लगा। इसके बाद आरएन सिंह मुझे लोहे के छड़ से कान पर मारा, मुझे याद नहीं किस कान पर मारा, मुझे मारकर आरएन सिंह भाग गया। मेरे मुंह तथा कान से खून गिरने लगा, मैं उठकर मॉनिटर ड्राइवर एसपी सिंह के पास गया। मैं उनसे घटना के संबंध में शिकायत किया, वह मुझे फर्स्ट एड के लिए गया। साथ में गणेश राम भी था। मेरे बयान को एसपी सिंह लिखा, मेरे बयान को एसपी सिंह लिखा तथा उस पर मैं अपना हस्ताक्षर किया। यही वह मेरा बयान है जो इस the preponderance of probability has to be needed. Departmental proceeding note, the oral evidences have come, the injured witness, the workman has deposed, it has happened with him, there is an injury report, doctor's report, that injury did happen, Other
The
workmen
person who
also.
had written the complaint has also not supported. He has
Well,
imposed
he
on
has
the
written-
side of the work.
He retired during the time when he was called for oral court examination. He retracted his statement, but not at that time. He himself recorded the statement, and the injured workman signed it. So those probabilities are there, and there is a not preponderance that nobody would falsely implicate somebody, specifically that I have bleeding from my nose and I have bleeding from my ear and my ear has been stitched. If somebody would have fallen on many people around the workman would have helped him, they would have taken him to the hospital. Here is a case of an altercation, exchange of abusive languages and scuffle, and then resulting into all this.
Para 16
So whether this was a preponderance of the probabilities or not has to be seen not in departmental proceeding. Strict rules of evidence would not be required to be not seen in such cases, and oral the proportionality notes. The Supreme Court has gone even to the extent of saying that even abusive language has been held to be not proportionate for a dismissal notice.
The point is that he has been held not guilty. So therefore there is no.
He has been disbelieved, not the evidence has been disbelieved. And nowhere has been discussed why it was not a preponderance of probabilities. It has been discussed not on the touchstone of a criminal trial. The award nowhere records that even preponderance of probabilities is not there. And the second witness not claiming to be a hearsay witness, but he was present on the scene. And on 1995, all of the three persons have given a different statement in the preliminary inquiry. So these are every
confronted them with their previous statements.
We have. Cross-examination has been not confronted.
What is the explanation?
Was why so negative? They were confronted. Of course, they were confronted. Can you see page 63? Yes,